session of the Portland City Council on Wednesday afternoon, February 7th, 2018. Carla, please call the roll.
Fritz.
Here.
Fish.
Here.
Saltzman.
Here.
Udaly.
Here.
Wheeler.
Here. The purpose of council meetings is to do the city's business, including hearing from the community on issues of concern. In order for us to hear from everyone and give due consideration to matters before the council, we must all endeavor to preserve the order and decorum of these meetings. To make sure the process is clear for everyone, I want to review some of the basic guidelines, which I hope will help everyone to feel comfortable, welcome, respected, and safe at the meeting to make sure that decorum is maintained. You should assume that people will come to the microphones who testify and they will have a difference of opinion from you. It's not a good thing if a room this full, everybody agrees on everything. So the name of the game here is hear everybody out, listen with respect, do not interrupt. If you are a lobbyist, please disclose you are a lobbyist. If you're here representing an organization, that's helpful too. If there are people here who are part of a group and you all have similar concerns, it's okay. If you want to appoint a couple of people to make your case, and then you're free to come up and stand behind the individual representing your group. Sometimes people prefer that. People have 3 minutes to testify unless otherwise stated. When you have 30 seconds left, you'll see a yellow light on the rostrum light up. When your time is up, you will see a red light. Please end your testimony at the red light. If there's any disruption, I will issue a warning that if there's any further disruption, anyone who's disrupting the meeting will be subject to ejection for the remainder of the meeting. If you're asked to leave and you don't, you're subject to arrest for trespass. That rarely happens, so we don't want it to happen, but those are the council rules. Before we get into today's item, I want to acknowledge some honored guests who are with us here today. In the upstairs, we have Mr. Stephen Ying, and he is shepherding a group of 8th grade students from Beijing. So welcome to our channel. With that, Carla, will you please read this afternoon's hearing item?
Item 132, appeal of the South Burlingame Neighborhood Association against the hearing officer's decision to approve with conditions Macadam Ridge, a 21-lot subdivision, environmental review with modifications, and environmental violation review for vacant property west of and adjacent to 0319 Southwest Taylor's Ferry Road, LU 16-213734 LDS ENM-EV.
Very good, thank you, Carla. First, the city attorney will make some comments about the proceedings today.
Good afternoon. This is an on-the-record hearing. It means you must limit your testimony to materials and issue in the record. The order of testimony is as followed. We'll begin with a staff report by Bureau of Development Services for approximately 10 minutes. Following the staff report, council will hear from interested persons in the following order. The appellant will go first and will have 10 minutes to present his or her case. Following the appellant, persons who support the appeal will go next. Each person will have 3 minutes, although as the mayor noted, council may amend the timing. The principal opponent, in this case the applicant, will have 15 minutes to address council and rebut the appellant's presentation. If there is no principal opponent, council moves on, but in this case we do. After the principal opponent, council will hear from persons who oppose the appeal. Again, each person will have 3 minutes. And finally, the appellant will have 5 minutes to rebut the presentation of the opponents to the appeal. Council may then close the hearing, deliberate, and take a vote on the appeal. If the vote is a tentative vote, council will set a future date for the adoption of findings and a final vote on the appeal. If council takes a final vote today, that will conclude the matter. There are several guidelines for those of you who are addressing council today. First, as I mentioned, the evidentiary record is closed. It's an on-the-record hearing. It's to decide only if the hearings officer made a correct decision based on the evidence that was presented to him. This means you must limit your remarks to arguments based on the record compiled by the hearings officer. You may refer to evidence that was previously submitted to the hearings officer. You may not submit new evidence today that was not submitted to the hearings officer. If your argument includes new evidence or issues, you may be interrupted and reminded that you must limit your testimony to the record. Council will not consider new information, and it will be rejected in the City Council's final decision. Second, if you believe a person who addresses council today improperly presents new evidence or presents a legal argument relying on evidence not in the record, you may object to that argument. And you may either do so by coming and talking to me, and we'll create a list, or if during your testimony you may raise it. New issues. Under state law, only issues raised before the hearings officer may be raised in this appeal to City Council. If you believe another person has raised issues today not raised before the hearings officer, you may object to council's consideration of that issue. And finally, the applicant must identify constitutional challenges to conditions of approval. If they fail to raise constitutional or other issues relating to proposed conditions of approval with enough specificity to allow council to respond, the applicant will be precluded from bringing an action for damages in circuit court. And that concludes my remarks.
Very good, thank you. Do any members of the council wish to declare a conflict of interest? There are no conflicts of interest declared. Do any members of the council have ex parte contacts to declare or information gathered outside of this hearing to disclose?
Yes.
Commissioner Fritz.
I visited the site at the request of one of the neighbours before the application was submitted. I gave general advice such as review the approval criteria, don't be rude to people, and stay focused on the issues within the report. And I have not heard from or visited the site since.
Does anyone present in the council chambers wish to ask Commissioner Fritz about her ex parte contacts or information that she may have received? I see no one in the council chambers. Is there anybody else who'd like to declare an ex parte contact? There are no other commissioners who are declaring an ex parte contact. Have any members other than Commissioner Fritz made visits to the site involved in this matter? No other commissioners have made visits to the site under consideration. Do council members have any other matter that need to be discussed before we commence the hearing? There are no matters to discuss. With that, then, we'll call for testimony. We'll start with the staff report, approximately 10 minutes. Come on up. Please introduce yourself for the record.
Council members, my name is Sean Williams, and I'm here today with.
I'm sorry, Sean, your mic is turned off. If you hit that gray button. Gray button. There you go.
Oh, there we go.
And stay about 6 inches away from it.
Good afternoon. My name is Sean Williams. I'm here with my colleague Kate Green, as representative of Bureau of Development Services. We're here today to present an on-the-record appeal hearing for land use case file 16-213734. This review is for a subdivision, environmental review with modifications, and environmental violation review. Project's also known as Macadam Ridge. This first slide that you'll see here is of the zoning for the property. The property is in the red hash marks. The base zone for the property is R10. It's residential 10,000. Allows a maximum density of 1 lot per 10,000 square feet. The property is approximately 14 acres in size. Almost the entirety of the site is located within the environmental conservation and protection overlays, with the higher level protection overlays being located over the waterways that are on the site. There is a scenic corridor overlay that is present over Southwest Taylor's Ferry Road, and the site is entirely within the landslide hazard overlay. For some context, here we have an aerial photograph. The site is outlined in red and has primary frontage on Southwest Taylor's Ferry Road. Additionally, it has frontage on Southwest Ruby Terrace and Southwest Hume Street. The site's located within the South Burlingame neighborhood. The South Portland neighborhood also borders the site to the north. One thing you'll notice here, the site's heavily wooded and traversed by both Stevens and Ruby Creeks. The site's adjacent to Riverview Abbey Mausoleum and across the street from the Riverview Cemetery. Other landmarks you'll notice here is I-5 to the north and the Willamette River to the east. So the map that you see here is of the preliminary subdivision plat. So the proposal is for 21 lots ranging in size from 5,000 to 7,924 square feet. 3 tracks are also proposed to be created as well as listed here. The proposal also will create new public streets and a pedestrian connection. And in addition, new utilities will be extended on the site to serve the development in the form of water, sanitary sewer, and stormwater. In addition to the land division review, there's also an environmental violation review. This review is to resolve the unauthorized work that occurred within the environmental zone that included cutting and topping of trees and shrubs in addition to some ground disturbance. This review was found to be met, or the approval criteria found to be met, subject to replanting of the disturbed areas. Should be noted that there's no objections to approval of the environmental violation review noted in the appeal. So the hearings officer approved the decision for land division to create 21 lots, 3 tracts, new public streets. An environmental review was approved for the proposed disturbance area. 2 environmental modifications were approved in addition to the environmental violation review. And these approvals were based on the approval criteria for land division in open space and residential zones, environmental review, environmental modifications, and corrections to violations. This decision was appealed by the South Burlingame Neighborhood Association for the following reasons, and I will go into these in more detail in the subsequent slides. The first being in regards to the issue of due process. What you'll see here is kind of a timeline of the review process. And here you'll see when the application was deemed complete, when a recommendation was made to the hearings officer, when the hearings occurred for this review as well. There were 2 opportunities provided to submit and address new information throughout this process, which were established at the discretion of the hearings officer. These timelines were in accordance with accepted practices. Unfortunately, there wasn't additional time to be provided for more opportunity to provide comments because we're at the end of the state mandated timeline for land use reviews, which brings up my next point that we need to make a decision on this appeal hearing today in order to abide by those timelines.
Could you tell me, please, what are the consequences of not abiding by those timelines?
I would like to defer to the city attorneys if I could on that.
Can you stop the clock, Carla, please?
An applicant has the opportunity, if the city doesn't abide by the 120-day timeline plus any extensions they've granted, to seek a writ of mandamus in circuit court. Through that, they could obtain approval of the application and attorney fees.
Thank you.
Can I just say, council, hasn't it been our practice in the past, if council needs more time if it determines it needs more time to deliberate, that we ask the applicant if they would consent to an extension?
We have, in this case, we're at a year plus.
I see.
But yes, that has been council's practice in the past.
Okay, so moving on to the next appeal point is regarding the environmental review. So environmental reviews are what we do as a part of those is look at establishing the limits of disturbance for a proposal that presents the least amount of detrimental impacts to the resources on the site. Mitigation is then required to compensate for those impacts. What you'll see here in this slide is a picture of Ruby Creek, which is a location where stormwater will be discharged via an outfall. It's also the location of where a new sanitary sewer main will be connected. And then additionally, the plan that you see here is of the construction management plan, which identifies the limits of disturbance for the proposal. The decision found that this criteria could be met subject to conditions that would allow for final determination of disturbance area through permits associated with street and utility construction. And the appeal indicates that the proposal does not present the least amount of detrimental impacts to identified resources. The next appeal point is regarding environmental modifications. Some modifications to lot dimension standards or site-related development standards can be requested as a part of environmental reviews if it's found that they could provide greater protection of resources and on balance be consistent with the purpose of those regulations. What you'll see here in this picture is the proposed conceptual development plan for the lots. So 2 modifications were requested. The first is to reduce the minimum lot area for lots 9 through 23 from 6,000 to 5,000 square feet in area. And the second is to reduce the minimum side building setback for each lot from 10 to 5 feet. The decision found that this criteria could be met based on substantial conformance with the criteria. And the appeal indicates that the proposal does not provide greater protection of resources, at least in respect to the modification to setbacks for lots 3 through 8 based on those lots meeting the lot dimension standards for the zone. The next appeal point is for tree preservation. So tree preservation requirements apply to land division proposals. When there's a concurrent environmental review as a part of a proposal, then we're really, for the most part, looking at maximizing tree preservation to the extent practicable. What you'll see here in this picture is of the upland forest area on the site. You'll see a lot of mature trees in this area. The decision found that this criteria could be met, and the appeal is contending that tree preservation is not maximized to the extent practicable because the environmental review disturbance area is unresolved. The next appeal point is...
Sorry, and questions don't count against anybody's time here.
Sure.
What do you mean it's unresolved?
So the disturbance area has not exactly been worked out because there's still some technical issues as far as how the streets and utilities could actually be constructed. And so because we don't know whether or not it's feasible to construct what's proposed, we don't know how much disturbance area would be associated with that.
Okay, thank you. I'll hold my further questions on that till later.
Okay. The next appeal point is regarding landslide hazard overlay. The entire site is located within this overlay, and what this criteria requires is that you locate development on the most suitable portions of the site so as to limit the risk of a landslide. In order to address this criteria, the applicant provided geotechnical reports and landslide hazard studies, which found that there would be no hazards generated from the proposal. The site development section of BDS reviewed these documents and concurs with those findings, and they're available today to answer any questions you may have. The appeal contends that the site is not suitable for development based on the presence of a historic landslide on the site. The final appeal point is regarding transportation impacts. So this criteria looks at evaluating the transportation system and ensuring that it's going to safely support the proposed development in addition to existing uses in the area, considering a number of evaluation factors. Some of the pictures you'll see here in the slides are of Southwest Taylors Ferry Road. The top one being in more close proximity to the frontage of the site, and the bottom one being at the intersection of Taylors Ferry and Southwest 2nd Avenue. And you'll notice there's a TriMet bus stop in that location, and then across the street there is the entrance to Riverview Cemetery. Some of the issues that were identified throughout the review process in regards to the evaluation factors are for safety for all modes and the availability of transit. The decision found this criteria to be met subject to either adding or improving a transit stop and removal of some vegetation to improve site distance. This criteria is being appealed on the basis of lack of access to transit service on the south side of Taylors Ferry Road. We additionally have Bureau of Transportation staff here today to answer any questions you might have on that. So the alternatives presented before you today are to deny the appeal and uphold the hearings officer's decision to approve the application with conditions, deny the appeal and uphold the hearings officer's decision to approve the application with modifications including revised conditions, grant the appeal and overturn the hearings officer's decision, thereby denying the application, and finally to grant the appeal in part and overturn the hearings officer decision, thereby denying the application with exception of approval of the environmental violation review with conditions. Thank you for your time.
Very good. Thank you. Commissioner Fritz.
On slide 2, if you could go back to slide 2, please. Why isn't the light pink part of that, of the entire property, why isn't that part of the site?
So that is just, that's indicating the property that's also owned.
But I thought that the definition of site means everything that's in the same ownership is contiguous.
Not for the purposes of a land division.
Okay. How was the determination of practicable made? You know, that this number of lots is the minimum number that makes the whole thing pencil.
I think you would have to have the applicant respond to that.
Okay, thank you. There was a condition about what the urban forester and the city engineer having to approve tree removal. What if they say no?
I suppose if they say no, then the proposal couldn't be approved.
Yeah, okay, thank you. And then I do have a question for transportation, either now or later. And that question is, why are half-street improvements on Taylor's Ferry not being, on the Taylor's Ferry frontage, why isn't the half-street improvement being required?
We are, Commissioner Fritz, Kurt Kruger with Transportation, we are requiring half-street improvement, sidewalk improvement along the limited frontage. It still would leave a significant gap down to Macadam or up to the top of the hill to Boone's Ferry.
Thank you.
So I just wanted to ask, could you once again just explain what is the condition for developing in a landslide hazard area?
Basically, the criteria asks that you demonstrate that the site is suitable for development. And in order to do that, what we require is a landslide hazard study that is provided by an engineer and a geotechnical engineer. And basically, they are evaluating, whether or not the site is suitable for what is being proposed. And we do have our site development staff here that could go into further detail on that too, if you'd like.
So if the applicant has a study by a geotechnical engineer that says you can do development in this site, even though it's a landslide hazard area, that satisfies the criteria?
It does, yeah. So the landslide hazard overlay is pretty much over almost all of West Portland. It's just an area that has a lot of these types of issues, so we ask for this kind of extra layer of review for these reviews.
Okay. Thank you.
I'm just curious, what, if any, impact is there on the Riverview natural area that may be relevant to our consideration?
You want me to speak to that? Hi, I'm Kate Green, for the record. We would anticipate that there wouldn't be any impact. The idea of the limits of disturbance is that there are no offsite or no impacts beyond those limits of disturbance.
So no stormwater runoff, no other detrimental impact to the sensitive streams and other habitat within the natural area?
In order to satisfy the approval criteria, they're supposed to delineate a limits of disturbance and demonstrate that they're not going to have any offsite impacts.
Okay, thank you.
Very good. Thank you.
Thank you.
We might call you back up later. The appellant, 10 minutes. And legal counsel, you will, of course, let us know if any of our questioning is not consistent with the standards you laid out at the beginning of the hearing. Thank you.
Good afternoon. Honorable Mayor and Commissioners, my name is Carrie Richter. I'm an attorney at the law firm Bateman Seidel. I'm here today representing the appellant, South Burlingame Neighborhood Association. I don't know if you need my office address, but it's 888 Southwest 5th Avenue, Suite 1200, 97204.
Typically, just so everybody knows, we don't need your address. Just name for the record sufficient.
Just my
and
address.
your affiliation.
This appeal raises two categories of issues: questions of whether the hearings officer properly applied the applicable standards, and two, whether the applicant provided substantial evidence to show that these standards are met. The applicant continually focused on the substantial evidence issue, claiming that plans were revised by qualified experts as the process went on to reflect shortcomings as they were identified by staff, and they were submitted into the record. The staff didn't object. Voila, approval. And I think that what we've submitted to you in writing and the people here testifying today are going to show you that the criteria were not met in the first instance, putting aside the evidentiary challenges. 4 of the 7 city bureaus noted defects in the proposal throughout the process. The applicant will say that they didn't comment during the final period, so they must have been satisfied. I urge you to ask them whether or not they were satisfied by the materials that were submitted. Rushing to revise the proposal left staff and the public shortchanged in its opportunity to review, resulting in a design that was not fully considered or refined. Compromising the environmental review. Examples of these shortfalls in evidence include failure to include riprap and rockery retaining walls and stormwater containment solutions within the area subject to disturbance. I believe Mr. Williams mentioned that determining where the roads will be will affect the area of disturbance. Until we know what the area of disturbance is, we cannot know whether the mitigation plan is sufficient. A couple of background facts that are essential to understanding this case, and Ms. Green mentioned them, so I won't delay the point, but we've talked about how this entire property is encumbered by various environmental protective zones. You've got the environmental protection area that protects the creeks themselves, and no development is allowed there. It will never be allowed there. The rest of the property is encumbered by a conservation area. The reason why this other area was encumbered by a conservation overlay zone is because of its upland forest. The Southwest Hills Resource Protection Plan identifies and maps the 4.57 acres subject to development as an upland forest area that is significant for its second growth stage forest cover that is home to over 60 birds and 30 mammal species. Therefore, the protected resources in this case are not just the streams, but the upland forest area as well, and that's why it's encumbered by EC. In contrast, the applicant identified 3 significant resources that are worthy of protection: Stevens Creek, Ruby Creek, and the forested area in the north section of the property. The reason for concluding that the northern 1/3 of the site, away from the riparian areas, was more significant than the forest areas on the rest of the site was not because of the forest characteristics. And it was not because of the wildlife that lives there. It was because the forest provides shade to Stevens Creek, which lowers the Stevens Creek temperatures. The functional value identified and acknowledged in the Southwest Hills Resource Protection Plan, the upland forest resources and the wildlife that call it home were never given any value by this applicant or the hearings officer. The upland forest on the north side of the property was valuable for what it gave to the creek, and not for its own intrinsic value. As a result, this 4.57 acre upland forest is slated to be clear-cut to accommodate a 21 lot development. The zoning code 33430.017 requires a design that will prevent harm to identified resources and functional values. Protection of the functional values of the valuable upland resource area required customizing and innovating the development to have the least impact on extensive timber resources. It required nestling the houses amid the forest rather than eliminating a large swath, 4+ acres, to accommodate a development. The hearings officer also erred by interpreting the obligation to have the, quote, least impact on protected resources based solely on the total percentage of overall disturbed land area, which they say is 29.5%. One of the environmental review criteria requires finding that the proposed development have the least significant detrimental impact based on a consideration of significantly different alternatives. All of the alternative considered focused solely on the percentage of disturbance impact. For example, in order to compare whether the disturbance area of 29.5 was an appropriate amount of disturbance, the applicant directed the hearings officer to other cases where the city has granted environmental review where disturbance limits were much higher. And in one of those cases, the impact area was greater than 29.5% in an upland forest area. But in that case, only 5 trees were removed. However, in this case, where the proposal is to remove 478 native mature trees between 6 and 54-inch diameter and another 3,326 trees at 13 inches or greater to be clear-cut. This illustrates that the obligation to have the least amount of detrimental impact should not rise or fall on the total disturbance area.
Ms. Richter, I'm sorry, would you say that again?
Yes.
Last, what you just said? With the number of trees, could you just go back 2 sentences and say that again?
Sure. In review, this approval will result in the elimination of a total of 478 native mature trees and 3,326 trees of 13 inches or less.
Thank you.
Further, it's our position that using the term 29.9% as a basis for evaluating the limits in the disturbance area is subject to manipulation. The applicant's claim suggests that the site was otherwise developable. The EP zoning along the riparian quarry takes this area of land out of the total that could be considered. And so, again, if you took the EP zoned land out of the total, the amount of land impacted would be higher. So again, we have concerns that that 29.9% is not really, it's just subject to manipulation in the way you look at it. One of the points that Commissioner Salzman asked about was the question of landslides and erosion and what criteria. And I want to point out another criteria that I think is really relevant and distinguishes this case. The obligation for environmental review is preventing harm to resources. And the Southwest Hills Resource Protection Plan points out that site soils are prone to slide and slumps when saturated. At particular risk are the steep sloped ravines. Erosion caused by the failure of these slopes would negatively impact the habitat and the water quality. The applicant will respond to this claim explaining that their area was extensively tested and the development will reasonably limit the risk of landslide under zoning code 33-632 that Mr. Williams talked about. But these studies failed to address and consider the significantly different alternatives, whether there were significantly different alternatives that would protect the functional values of the natural environment better to protect the wildlife and the upland forest from risk of landslide, which is specifically identified for protection in the Southwest Hills Plan. The alternatives, the applicant says it considered different access configuration, different lot configuration, different housing types, but they did not consider whether it was possible to preserve a significant grove, a particular wildlife habit, or a 200-plus-year-old 54-inch tree by customizing a development that would work with the trees and work with the forest and work with the wildlife. Finally, ZC 430.250A1C requires the provision of a mitigation plan which demonstrates that all significant detrimental impacts on resources and functional values will be compensated for. Again, the hearings officer and the applicant gave no value to the upland forest values that make up the Southwest Hills Plan and led to the EC zoning in the first instance. The mitigation plan was submitted by the applicant in January of 2017, before the hearings process commenced and before there were substantial changes in the proposal. The hearings officer's decision does not reflect changes to the mitigation plan resulting from, the hearings officer's decision does reflect changes to the mitigation plan resulting from the additional detail, but it doesn't talk about overall project mitigation, overall project overall protection of the forest generally. Coming back again to sort of the opening concern, the mitigation plan is deficient because the disturbance area was not known. The applicant recoils at the idea of setting disturbance areas, citing the need for flexibility. And generally, unknown construction activities happen and you have to make adjustments. But the code clearly requires that an applicant within environmental review set a clear limitation on disturbance within resource areas. Clear limitations are not boundaries that are adjustable when it is convenient for the construction crew. With this, I ask that you uphold this appeal and overturn the hearings officer's decision. I'd be happy to answer any questions you may have.
Perfect timing. Commissioner Fritz.
Do your clients have any opinion on whether the environmental violation review should be approved?
I think we would be fine with the mitigation that a city has identified.
Thank you.
I have a question.
Commissioner Fish.
If we're not clear about defining the disturbance area and we're building in a certain level of flexibility and we get it wrong, what's the remedy?
A loss of habitat, I think, is the remedy of getting it wrong. You mean as far as an enforcement action, we've blessed it at that point.
Right.
We have signed off on it. That's why this is so dangerous.
Thank you.
Very good, thank you. Next up, supporters of the appeal. You can sign up. I believe the sign up is still, it's in Carla's hands. Again, you don't have to use your full 3 minutes. If you want, you can just say, I agree with what the last person said, or you can say, I agree with the first 2 points and want to add one more. Or if you prefer, you can just stand behind whoever is representing your interests. You are, of course, entitled to your 3 minutes. I just want to suggest alternatives if people would prefer. Carla, how many people do we have signed up?
We have 35,
So,
36.
36. So,
37.
the question now is, how long do you want to sit here? So, if you start hearing testimony that sounds a lot like yours, just come up and say, my 3 points have already been made, but me too. Or whatever you'd like to say is sufficient. That's good. All right, first three, please.
Are Carol Hazard, Marilee Carr, and Matthew Boyes, and they'll be followed by Jan Friedman, Dave Polson, and Krista Peterson.
Again, name for the record. When your 3 minutes is up, the light goes off, and that is when I would like you to end your testimony. Thank you. Would you like to start for us, please, today?
Yes, my name is Carol Hazard. I live at 3232
You don't have to give your
Southeast.
address.
Pardon me?
Don't give your address.
Yeah, we
I'm
don't
sorry.
need addresses.
Okay,
just name for
good.
the record is sufficient. Thank you.
All right. I've been a Portland resident for 52 years, living all that time on the east side. My husband and I lived in Alameda for 38 years. We have lived in the Reed neighborhood for the past 14 years, and our children and grandchildren live in Portland. As a concerned citizen, I recognize the need for new development in our city, but my greatest concern is that development should be safe and in the best interest of all citizens. It is my opinion that this development will put hundreds of people and their homes at risk. Hearings Officer Odin Orr failed to apply Code 33.632.100 that states that the development site must be suitable for development in a manner that reasonably limits the risk of a landslide affecting the site and adjacent sites. He did not give nearly enough credence to the known factors that reactivate landslides. This decision clearly puts families at risk. The state of Oregon's Guide to Landslides states the presence of previous landslides is one of the biggest and most obvious risk factors for recurrent landslides. This site is a translational site, which is commonly triggered by heavy rain, rapid snowmelt, earthquakes, grading, removal material from bottom of a slope, adding loads to the top of the slope, concentrating water onto a slope as with landscape irrigation, roof downspouts, or broken water sewer lines. Essentially, 5 of the 7 points to avoid reacting a landslide will occur with the Macadam Ridge development. They are upland forest that stabilizes the ground overlaying the landslide, will be clear-cut, and will be replaced with impervious surfaces that will concentrate water on the slope. Land will be graded and cut from the bottom. 20,000 cubic yards of infill will be added as a load to the slope. Tons of building material will add to the load and will create impervious surfaces which will concentrate water on the slope. Since there is no mitigation for uphill groundwater groundwater, water will be concentrated even more on the slope. The applicant has chosen to place this nearly 5-acre development on the most unstable ground they own, an ancient landslide. And to add insult to injury, their plan completely removes all the existing stabilization from the nearly 500 big trees and thousands of small trees that will be clear-cut. There are nearly 15 acres on the site, and the applicant never considered an alternative that would have completely avoided this large, high-risk hazard. The hearings officer should have weighed the considerable risk thoroughly before approving this development, because the environmental codes for Type 3 land divisions require the significant detrimental impacts are to be used for the development. Therefore, I believe the subdivision application should be denied.
Thank you. Good afternoon.
Afternoon. Mayor Wheeler and city councilors, my name is Marilee Carr. I am the team leader of the Neighborhood Emergency Team, or NET, in South Burlingame, the neighborhood of the proposed development. My concerns are my own. I do not speak for the Portland Bureau of Emergency Management, which runs the NET program.
However, thank you for your participation. We appreciate that very much.
Sure. NET members are volunteers trained by Portland Fire and Rescue as amateur first responders. We can and will be on the scene of disaster before professionals with heavy equipment arrive. As I assess hazards around my neighborhood, I look at houses set on slide-prone ground as coffins. These houses on unstable land that has slid before will sooner or later give way in a big rainstorm or an earthquake. Building the proposed development will further increase the precariousness of this slope by removing the trees whose roots are now holding the soil in place. Nets are trained to extract people from rubble, but not from mud. If you allow these coffins to be built, my team will be there when they slide, trying to save our neighbors' lives and living ever afterward with memories of partial success, if any. My neighborhood holds other coffins too, structures that pose extreme seismic danger. They are homes built of unreinforced masonry, or URMs. They will collapse in a strong earthquake, threatening lives both inside and outside the house with a rain of bricks. No one can build URMs anymore because Portland's seismic vulnerability has literally made itself felt. Our vulnerability to landslides is also well established, but more recent. In February 1996, heavy rain and snowmelt caused 700 landslides in Metro Portland, with major damage to more than 100 homes. Building on landslides should be as unthinkable as building unreinforced masonry. I hope you agree and vote to stop this ill-considered and dangerous development. Thank you for the opportunity to explain our concerns.
Thank you for your testimony. Good afternoon.
Hello, Mayor Wheeler and City Council members. My name is Matthew Boyes, and I'm a resident of South Burlingame. Thank you for taking the time to hear our neighborhood association's appeal. The SBNA has been working as an engaged group to positively influence this land division for many years without success. We have serious concerns we will share with you today, but the most grave is in regards to the landslide and traffic safety. Devastation to the habitat and wildlife in the proposed land subdivision and the value of its unique resources will be articulated today. Out of respect to you and your time, we have prepared and organized our testimonies to be as succinct as possible. We have asked people to allow a few of us to express all of our concerns as a collective, and with many more showing their solidarity behind us today. While we are not opposed to developing this property, we feel the current application has too many risks. Our goal is to share with you evidence and testimony that should compel you to deny the Macadam Ridge application, as Riverview Abbey did not meet the burden of proof required by Mr. Odin Orr to approve the application. And these are going to the clerk.
Good. Thank you. Appreciate it.
Hi, I'm Shannon. I'm part of the SBNA. I'm helping to navigate the PowerPoint for our group. Is it possible, I've expanded it, but it doesn't appear to be showing on the video?
There it is. There, I fixed it for you. I hope you're happy.
Thank you. Thank you.
Very good.
He is the mayor after all.
You're good.
And if it breaks again, I've delegated the duty to Carla over there, because she's really the genius here. Very good. Thank you for your testimony.
The next three are Jan Friedman, Dave Polson, and Krista Peterson, and they'll be followed by Carol Lidberg, Lorraine Zunwalt, and Scott Richmond.
Okay, and just so I understand the logistics of what you're proposing, and that legal counsel understands what you're proposing, you're still going to stay within your 3 minutes, but while you are testifying, there will be a PowerPoint, is that correct?
Correct. We will, I believe we have 23.
Can you speak into the microphone?
Sorry. I don't have a mic.
And if you could just identify yourself again.
My name is Shannon Hiller-Webb. I'm part of South Burlingame neighborhood. We have 23 people representing our neighborhood in our narrative, so the PowerPoint will follow the entire 23 pieces of testimony.
Okay, very good. And you have no problems with that, legal counsel, I assume?
This is, I mean, my sense is this is unusual, so I'd be interested in what legal counsel says.
So I'm assuming that it's probably more efficient rather than having each individual person click on the button for their slides. So I'm assuming that what she's doing is providing technical assistance as we might when we have presentations by staff members. So I don't consider the slides to be Shannon's testimony. I'm assuming it relates to the testimony, and I also assume that both staff and the applicant will let me know if there's any new evidence that shows up in the PowerPoint.
Very good. So counsel, then we will rely on the city attorney if there's something that isn't in accordance with the hearing structure, you'll let us know. Very good. Thank you. Sorry for the delay.
No problem. Good afternoon, Mayor and Commissioners. My name is Jan Friedman, and I'm a member of the South Burlingame Neighborhood Association. I've lived on... Is there a problem with the sound? Okay.
One second, Jen. Let's make sure we get this
Shannon,
straight.
is that what's supposed to be up there right now?
Yeah, this is Jan Friedman.
Okay.
So we don't, is it your intent that we'd actually, oh, I see, okay, sorry.
I was just waiting for her to finish anything.
So I've...
We screwed you up. Do you want to start over?
Yeah. Okay. I am still Jan Friedman, and I've lived in the Southwest Burlingame neighborhood for the last 19 years. I live on Southwest Ruby Terrace. I live in the landslide zone, and I'm part of South Burlingame Neighborhood Association. I've been a citizen of Portland for 30 years, and I've been a practicing attorney in the civil rights arena mostly for the last 28 years. I'm here to ask you to deny this application and overturn Mr. Odenor's decision. There are many bases for this. The one I'm going to address is due process, which, as you recognize, is a fundamental constitutional right that all of us share in this country. It involves notice and opportunity to be heard. It also interfaces, in this case, with the Administrative Procedures Act, which says that the officer presiding at the hearing shall ensure that the record developed at the hearing shows a full and fair inquiry into the facts necessary for consideration of all issues properly before the presiding officer in the case, and the correct application of the law to those facts. That's ORS 183.417 sub 8. So there have been numerous instances where our due process rights were violated. Sorry.
Thanks, Carl.
Do you want me to keep going?
Yeah,
okay. One of them was on October 30th, we showed up for the hearing, and hundreds of pages of information were given to us. We were pro se, and a lot of key information was given at that 11th hour. Now, the applicant will say this is a four-year process, but we have neighbors who aren't represented getting hundreds of pages of documents with 1 week to respond. Mr. Odenor at that time said, I wish I could give you more time, but he didn't. But later did, through an interim order, provide some additional time, but that was over the Thanksgiving holiday, and it was on the 20th, starting the 20th. So we were really not able to mobilize and to get information in a way that would be meaningful. He also violated our due process rights. If you look at the decision, 100 pages, we are listed on the last page in the exhibit were listed for oral testimony, although I'm not listed on October 16th, even if I did provide oral testimony on that day. And we're listed on page 10, which is a cite to the Bureau of Developmental Services, quoting a synopsis of some of what we had to say. And that was from October 16th. The matter didn't end on October 16th. So basically, we were ignored in his decision. Mr. Odenor looked at the applicant, looked at the bureaus, looked at the applicant, and said, okay, I go with the applicant, and I'm going to add some conditions. So what that did was it excluded us from being heard. Where are we in there? Where's the substance? There's really no substance provided in terms of what the 86 written testimonies were and all the oral testimonies were. Thank you for your consideration in this important and complex matter.
Thank you, you bet. Good afternoon.
Good afternoon. My name is David Polson. I'm the Senior Principal Engineer for Pace Engineers in Lake Oswego. We're a company of about 80 total consultants, focusing mainly on land use planning, civil engineering, and environmental engineering. We were retained by the South Burlington Neighborhood Association to provide an oversight of this development application. And I want to read from an email that I wrote after, and I'll explain later why I wrote this email. Per our scope of services, Pace Engineers was retained to review publicly available documentation submitted for Macadam Ridge and offer our opinions regarding whether it was consistent with the development code. Moreover, we understood that through the course of the Macadam Ridge entitlement process, SBNA was seeking professional services that could review and respond to engineers and consultants that the developer has retained. It is common and reasonable for SBNA to retain these professional services to provide knowledgeable and qualified responses as would be appropriate for any Type 2 or Type 3 land use process. When Pace agreed to provide these services, it was with the understanding that we could develop an open and productive dialogue with the City of Portland and with the developer in the interest of gaining an understanding of all perspectives and representing the interests of SBNA. Public comments provided by SBNA members and others, including peer-to-peer exchange among professionals, should not only be freely encouraged, but strongly desired by all parties as an important aspect of facilitating a comprehensive entitlement process. That's the introduction. Then we just began our services. We did a couple $1,000 cursory review of the project, and then we attended one of South Burlington Neighborhood Association's meetings to discuss the project. I had a couple of consultants, an engineer and environmental planner, attend that meeting and offer their initial comments about what they had from their initial review. After that meeting, we got a letter, I received an email from Mr. Griffiths, the developer, that says this. It says, my family owns the property in Southwest Portland that is being developed for Macadam Ridge housing. I've got much time. I'll skip the introduction. I attended the SBN meeting last night at Capitol Hill School. During that meeting, you both heavily criticized Macadam Ridge development. I'm very troubled by your statements. My development partners and I invested over $500,000 over a period of 4 years to obtain entitlements on the property. We've been damaged by your actions. You illegally obtained information by trespassing on our property. Our property is posted with no trespassing signs. You slandered the engineers and consultants that we hired from Macadam Ridge. You made multiple inaccurate statements. Sorry, my time's expired, but I'm saying that I think you would have heard a lot more today had I been retained and didn't have this intimidating email sent to us.
Thank you. Good afternoon.
Good afternoon. My name is Krista Peterson. I'm an 18-year resident on Ruby Terrace, and I am a member of the South Burlingame Neighborhood Association. I am here today to express extreme concern about the transportation impact approval criteria 33.641.020 and 030 on the surrounding neighborhood and thoroughfares for our citizens. To begin, a few facts that are widely acknowledged and accepted regarding Taylor's Ferry, where the Macadam Ridge development is fronted, and observations to evidence presented. Taylor's Ferry Road is unsafe for pedestrians, bicyclists, and mass transit riders due to limited sight distance, blind spots, and a lack of methods to safely cross the street. Taylor's Ferry has no roadway shoulders, only drainage ditches on both sides of the street. There are no sidewalks or curbs present on Taylor's Ferry except small portions intermittently placed at business fronts. There are no sidewalks from bus stop to bus stop. The intersections at Southwest 2nd and Taylor's Ferry and Southwest Terwilliger and Taylor's Ferry currently do not meet City of Portland operation standards. The 2015 traffic counts submitted by the applicant do not reflect true traffic flow because Selwood Bridge traffic was non-existent due to the closure and long-term sewer work was being completed on the Terwilliger Boulevard extension. Taylor's Ferry is massively overburdened during morning and evening rush hours at the intersections of Terwilliger Boulevard to the west and Macadam Avenue to the east, making access in and out of the neighborhood difficult. The adjacent neighborhood populations do support transit. Consistently low ridership is due to lack of access and unsafe nature of these locations. PBOT has denied this application for reasons that remain unaddressed by the applicant. It should be noted, a devastating crash occurred February 17, 2016, whereby a pedestrian was struck not once but twice by passing vehicles after exiting a TriMet bus while attempting to cross Taylor's Ferry from the south side. In this case, the teen narrowly escaped death and is still rehabilitating to this day. I shudder to think that a death is required before any action is taken. These facts are undeniable. Hearings Officer Odin Orr did not correctly apply the following code criteria: availability of transit service and facilities and connections to transit, and impacts on the immediate and adjacent neighborhoods. At this time, all eastbound bus stops along Taylor's Ferry should be considered unusable for those on the north side of Taylor's Ferry until there is a safe way for pedestrians to cross the street. The south side of Taylor's Ferry has no residences, only a cemetery and green space. All pedestrians would come from the north side of the road. TriMet's published bus stop guidelines referenced in Michelle Weifel's October 25, 2017 communication with Mr. Kobach state, it is essential that bus riders have safe access to their bus stop. Walking on narrow roadway shoulders through mud or puddles or through ditches is unacceptable to most riders and is often unsafe. I'm going to run out of time, so. Mr. Kobach's assertion that the evidence of TriMet's response to this issue is critical, based on Weifel's assessment that a full sidewalk along Taylor's Ferry is not necessary, is contradictory. If TriMet does not hold responsibility for construction or maintenance of sidewalks or curb ramps, why would this opinion be critical? Has anyone even visited the site in this past year? The intersection of Southwest 2nd Taylor's Ferry is completely inaccessible.
Thank you.
Thank you.
Next three, please.
Are Carol Lidberg, Lorraine Zumwalt, and Scott Richmond. And they'll be followed by Shannon Hiller-Webb, Dave Hennington, and Robert Lennox.
Good afternoon.
Good afternoon. Mayor Wheeler and Commissioners, my name is Carol Lidberg, and my family has lived on Southwest Ruby Terrace for more than 15 years. I am also part of the South Burlingame Neighborhood Association and strongly oppose this decision by the hearings officer. I would like to speak briefly about safety for all modes. That means pedestrians, bicycles, cars, and transit users should have equally safe passage on our city streets. While other areas and streets of Portland are maybe more significant for their accident rates and challenges in Southwest Taylor's Ferry, that does not diminish the factors that currently exist on this section of the road and will only get worse with this construction unless the applicant is forced to follow code and reflect necessary changes in their design proposal. The Griffith family business is adjacent to Taylor's Ferry, and I'm sure one or more of them spend time in the building. However, they still do not live in the neighborhood like most of us speaking today. And when the development is built, they still won't, but we will. The applicant needs to be held to the letter of the code and make necessary changes in concert with TriMet and PBOT to the access points of this development with both Taylor's Ferry and Ruby Terrace neighborhood. They've been given ample time to do so, more than 4 years, and still have not made the appropriate effort. There are no consistent sidewalks. Bicycle riders are forced to ride in the travel lanes and cut through the Riverview Cemetery. And the lack of development along this area makes speeds increase and elevation changes and curves equal hazard all around. The best we can hope for at this time are some improvements to the transit access. The final decision does require the applicant to trim bushes and prepare a pad for the stop on the new sidewalk, but we don't feel that is enough to make the road safe for pedestrians. At the very minimum, we ask that a crosswalk be included in the requirements for safe crossing from the eastbound bus stop to the proposed development on the west side of the street. Taylor's Ferry is dangerous for all modes of transportation today and will remain dangerous if Macadam Ridge is allowed to happen. My hope is that the Riverview Abbey Mausoleum and the Griffiths consider people's lives above profit in pursuit of this development. The irony of this statement is chilling. Living right next door to the mausoleum could be a constant reminder of a life cut short. In concert with PBOT, I ask that you deny this application and reverse the hearing officer's decision. Thank you.
Thank you. Good afternoon.
Hi, my name's Lorraine Zumwalt, Mayor Wheeler and council members. Thank you for your time. I grew up in Southeast Portland and have lived in South Burlingame for 29 years. I'm a registered nurse and have spent my career as a pediatric nurse. So the concern and welfare for safety of people has always been sort of my priority. So I'm here on behalf of our neighbors and the teen you heard about when Krista talked. I want to read a letter from his father. He couldn't be here today. Excuse me. I have lived for 21 years at Taylor's Ferry Road next to the proposed development. On this stretch, the speed limit is 40 miles an hour. Residents have complained for years about endless traffic accidents. The cars and motorcycles continually drive at 45 to 50. There is no sidewalk, bike lane, walking lane. It's hazardous. Despite the claims to the contrary, the applicant's counsel said there is considerable bicycle and foot traffic every day on this stretch of road. I've seen mangled bicycles, badly injured people on the ground, dead deer, coyotes on the side of the road, 4 snapped telephone poles, many cars off the road, and smashed fences. 2 years ago, on February 17th, my son got off the TriMet bus coming home from school using his Wilson High School bus pass. After exiting the stop in the dark and the rain, he tried to cross 3 lanes of traffic and was hit by the cars. There was no provision for safely crossing Taylor's Ferry Road. He spent the next 3 months in the hospital, and his life will never be the same. The pain and heartache that our family has endured cannot be put into words. I appeared at the public hearing on October 16 and explained this to the hearings officer. As an expert in data analysis with a master's degree in mathematics, I also submitted documents identifying the fundamental methodology flaws and factual errors that the impact study had that was submitted by the applicant. The hearing officer brushed aside the clear recommendation of PBOT against the Macadam Ridge development. So I'm asking the City Council to consider the health and safety of our children and deny this application. Sincerely, Michael, excuse me, Baranow, and as a mother and as a nurse and as a concerned citizen, I'm asking you to deny this application for safety reasons. Thank you.
Thank you. Thanks for your testimony. Good afternoon.
Good afternoon, Mayor and Council. My name is Scott Richmond. I'm a resident of South Burlingame. I've been for about 15 years, and I'm our Neighborhood Association's representative to the Southwest Neighborhood Inc.'s Transportation Committee. I'm also on our Neighborhood Net team, as Marilee Carr spoke earlier. I'll keep this brief, as others have voiced concerns that I plan to raise regarding transportation, in particular about my concerns about the deficiencies, the current deficiencies of Taylor's Ferry Road, the closest arterial that will directly serve the proposed development. The developer applicant, in their favor, has case law precedent that they cited about disproportionate exactions, and so the city is somewhat hamstrung in terms of how much they could burden, so to speak, the developer with what the developer is saying are potential offsite improvements. But I would encourage you to not approve this application in large part, in addition to the concerns raised earlier about environmental hazards, landslides, and so forth. Just about the inadequacy of the transportation infrastructure. The developer is proposing, at least considering, has a condition to improve a TriMet bus stop, a pad that would serve one direction of the Route 43. It wouldn't do anything to address the direction of travel from the development to downtown through Macadam and John's Landing into downtown using the 43 route. That would be considered an offsite improvement, but I urge you to strongly consider the current deficient system, including Taylor's Ferry, and as Marilee noted about the future residents of such a development and us needing to respond to them in the event of a landslide. I'm also very concerned about a lot more flashing lights from ambulances, paramedics, and so forth because of the risk that we're taking on by approving additional travelers along Taylor's Ferry Road at that location. Thank you.
Thank you.
Next three are Shannon Hiller Webb, Dave Hennington, and Robert Lennox. And they'll be followed by John Holderness, Michelle Lennox, and Carol Hazard.
May I request that I stay here because I have to control my own media, which is a video?
Yeah, of course.
Okay, great.
So, Mayor, this is the city attorney speaking.
Wait a minute, not so fast. The
One
voice
of the
reason.
things that's difficult about the PowerPoint is that in terms of looking at the hearings officer's decision to determine whether these materials have been previously submitted, if somebody is having slides associated with their testimony, I would appreciate if they would identify whether those materials were submitted before. I mean, for example, the emails that were submitted in the KGW article, I don't have any way of looking at the hearings officer's decision and the list of exhibits to determine whether those were previously submitted.
May I follow up with that?
You may.
We've cited all of this referenced in our PowerPoint and various documents where they've been introduced into evidence or where we're relying on city council recognized and approved ordinances. Okay. So you would like us to identify when it was introduced into evidence, if at all possible, each time?
It would be useful, but if you don't know, we'll end up having to figure it out later. But.
Okay, well, happy to be helpful.
But for instance, with that newspaper article just saying this was submitted to the hearings officer, that would be what we would need.
And in that case, that was submitted with Michael Barano's testimony on October 30th. It was...
Wow, no, I don't need all that. That's just tell us. Yeah, that's perfect. Thank you.
Okay.
Good job.
Thank you.
What time of day was it?
What was the weather?
I'm happy to find that out for you. Okay. So if you just give me 1 second just to get my media set up. Okay. My name is Shannon Hiller Webb, and I have lived in South Burlingame for 33 years, and I'm a native Portland resident. I want to state my position is that I support development in our city, but just not at all costs, and this development harms valuable identified resources and risks the safety of my current and future neighbors. I come to you today having carefully considered this project. I ask that you respect that 5 of 7 of your bureaus denied the Macadam Bridge application, and I believe the hearings officer erred in his decision in applying multiple codes. I would like to share a video of the area we are discussing that I introduced to the hearings officer with my oral testimony on October 30th. As the video plays, I would like to share how the land has been characterized, demonstrating its value by BES and the Southwest Hills Protection Plan. 1 second. Sorry, technical difficulties to transfer. Okay. This isn't the, we loaded this video, there we go. The forested Southwest Hills form a backdrop to the city, and their destruction would result in loss of identity, uniqueness, character, and value. There are 130 plant species that include Douglas firs, western red cedars, Pacific dogwoods, as well as protected Stevens and Ruby's creeks that are critical to endangered Chinook salmon and steelhead trout migration. In addition, there are 31 mammals and 74 nesting bird varieties, including the northern flying squirrel, the only flying squirrels found in North America. Bird species observed include great blue heron, cedar waxwing, golden eagle, red-tailed hawks, owls, and ducks. Pileated and downy woodpeckers, which are native to Portland and the largest woodpecker native to North America, are found here. Mammals in the area include mule deer and foxes. In addition, the forest mutes the noise of highways I-5 and 43, absorbs some air pollutants caused by audio and industrial emissions, and moderates climate extremes. The forest cover is in its second growth stage with a 70% deciduous and 30% coniferous composition. Red alder and bitter cherry are common associates of the maple. Several unusually large specimens of Pacific dogwood and cascara are present, and the understory shrub story provides wildlife food and cover. There are 6 perennial creeks, including Stevens Creek. This site has important visual resources. The tree-covered condition of the site contributes to the neighborhood character. Because of the relatively high ridge elevation, broadness, and tree cover, this ridge is an important feature of the West Hills and the surrounding region. This entire 4.6 acres will be clear-cut to make way for homes, and 478 native trees ranging between 6 and 54 inches in diameter will be sacrificed. Simply put, once destroyed and built upon, we will never recover the functional value of the environmental ecosystem and the habitat loss.
Thank you. Good afternoon.
Good afternoon, Council and Mayor. My name is David Hennington, and I'm here today to present my perspective as both a human and as an individual educated and trained in environmental sciences and land use planning. My hope is that this will help convince you to reject the approval issued by Mr. Odenor. As a human, I have lived immediately adjacent to this impressive, intact, temperate rainforest for nearly 8 years. I have seen and heard dozens of wild animals, such as those listed by Shannon previously. I have also seen and heard the terrestrial mammals that face the daily struggle of navigating the increasingly rigid and dangerous confines of our man-made landscape, such as deer and coyotes. Hiking nearby at night, aided by a headlamp, I have seen the watchful, glowing eyes of multiple coyotes wary of my presence. There is no doubt that this is truly a wild place, and as a human, I am compelled to speak up in defense of it. As an individual whose education focused in large part on urban forestry and whose professional experience includes reviewing and residential and commercial tree plans, I see a large, intact urban forest composed of hundreds of significant native specimens, some of which can be clearly classified as old growth and many others as second growth. Looking at the plans, I see an outdated approach that assumes a clean slate is best practice and disregards the functional values of the trees it so callously disposes of. You've heard the 478 number on the mature trees. I'd like to point out, in addition, 59 native trees of 21 to 25 inches at breast height, 19 of 26 to 30, and 53 above 31, including one that is 54 inches. These are all trees that are likely to be at least 100 years old, and the biggest one is estimated to be around 270. As shown in supporting documentation, the site is a critical link as part of an established wildlife corridor. This whole part really stuns me. So BDS staff have determined that the most recent version of the submitted application does not adequately address a lengthy list of critical environmental review approval criteria. And there's a quote I've added that basically just shows that that's the case. And so with these facts and with the obvious criticality of this mature, temperate rainforest habitat in mind, I am shocked that this proposal could have so casually been approved. I call on you as passionate leaders of our community to defend the laws, policies, and plans of our community. I call on you to defend the processes and labor of the professionals within your bureaus, and I call on you to right this wrong and overturn Mr. Odenor's approval. Thanks so much.
Thank you, appreciate it. Good afternoon.
Good afternoon, Mayor and council members. My name is Robert Lennox. I'm the president of South Burlingame Neighborhood Association. I'm also a professional land surveyor. I've been practicing for about 20 years in the state of Oregon. I'm going to get into code. So approval code, criteria code 33-430-2550.A4C talks about design including building sites, vehicular access, and utilities within the resource areas of a conservation zone must have the least detrimental impact on identified resources and functional values as is practicable. Significant different but practical development alternatives, including alternative housing types and reduction in the number of proposed and or required lots, may be required if the alternative is less impactful on the environment. So as described, the north half of this site is encumbered by 2 creeks. It also has a portion that's a landlocked upland forest that they've called out. It's also somewhat of a remnant parcel where encroachments or development has happened on multiple areas, so it's a really unregular shape, making it very hard to develop. Basically, the proposed areas focus on the south 4.5 acres of the property. The Southwest Hills protection plan lists resources and include many things, but to the note are the ancient mapland site and the trees to the southern side of the parcel near Terry's Fairley, which includes the 54-inch diameter tree. So what we have here is a look at the evidence that's been put into record. This has been put in by their attorney. The first four are the alternatives that were submitted with the application. 4A is the preferred, and the rest of them were submitted at the time of the hearing. The next slide is basically just zooming in on them and making them all the same size. This slide basically highlights the lots and it highlights the roads. This is the proposed area of impact. This is what we're talking about. The first two, these two that we have access through, the applicant said that they weren't practicable. One of them was designed in 1890, 1840. It ignored all topology, ignored all the streams, ignored everything. The other one had a bridge going over the protection zone and wasn't practicable to build. The remaining ones we're going to show here as they overlay on the screen basically follow the same design. They basically discount everything on the south side of this creek. All the trees, the 505 trees, everything else that's down there. You'll notice that there's no proposal of innovation and planning. There's no multi-family condos done. There's no cluster homes. It's very intensive, and it's very hard on the upland forests. So basically, also the analysis was basically reduced, as our attorney said, to percentage of lots in an area. So we felt that Old Nor failed in his application of this code to require multiple alternative analysis.
Thank you. Appreciate it. Next three, please.
Are John Holderness, Michelle Lennox, and Carol Hazard, and they'll be followed by Roger Zumwalt, Linda Meyer, and Seth Dryden.
Good afternoon.
Good afternoon, Mayor, City Council. My name is John Holderness. My wife and I live on Ruby Terrace in South Burlingame. We particularly value Portland's green spaces, and we hike on the city's trails regularly. I'm a retired technical writer. I'm also a net volunteer. To save time, I'm leaving out some details that I included in the written version I sent you earlier today. I'm here to state my view that the hearings officer, Mr. Odin Orr, did not correctly apply City Codes 33.430.250 and 33.630, as most of his findings directly counter the expertise and code requirements outlined by BES. I'll be focusing on two valuable resources, Stevens Creek and the 54-inch Douglas fir on the site. The city has invested over $1 million to improve stream conditions on Stevens Creek by repairing a sewer line along the course of the creek, reconstructing the stream bed, and restoring native vegetation. Groundwater mitigation is absent in the plan for this development, and therefore Stevens Creek and the city's investment are at risk. There's also, as you've heard, a 54-inch diameter Douglas fir tree on the site. It's estimated to be over 200 years old, maybe 300. It was here before Lewis and Clark. Due to an oversight on the applicant's part, the city didn't notice this high functional value tree at first. The applicants claimed the tree could not be saved because the city's comments came late in the review process, essentially blaming the city for the applicant's error. The applicant said it had to be cut down because to save the tree, they would have to redesign the subdivision, and the cost of redesign was too high. But there's no way to put a price on this tree, the largest and therefore the highest functional value for habitat of all the trees on the site. The code requires that this site, with its protective environmental overlays, be developed first and foremost with sensitivity to the high functional value of all the assets within the conservation zone. Code 33.430.A1A says, quote, trees that are healthy, native and non-nuisance species, 20 inches or more in diameter in tree groves are the highest priority for preservation. The hearings officer failed to apply this code correctly in his decision to approve the application. This was an error. we ask the council to protect the Stevens Creek watershed and preserve this tree. I request that you overturn the hearings officer's approval on behalf of this watershed, this tree, and we, the local citizens. Thank you.
Thank you, sir. Perfect timing. Extra credit. Good afternoon.
Good afternoon. Thank you, Mayor Wheeler and City Council members. My name is Michelle Lennox. I am a property owner that is adjacent to the ravine that supports Ruby Creek. I've been a resident there for 23 years, and I support the South Burlingame Neighborhood Association's assertions. The hearing officer erred in approving this application because it does not meet the Southwest Hills Resource Protection Plan policies. In particular, Environmental Code 33-430-250A1 and Code 33-632-100 requires this project be suitable for development in a manner that reasonably limits the risk of landslide affecting the site and adjacent sites. The hearing officer erred by not requiring the applicant to identify the upland forest located in the southerly region, which happens to be the area of primary disturbance, as a functional resource and value from the beginning. He failed to consider forest ecology as one of the key functional resources that must be preserved. To quote from Southwest Hills Regional Resource Protection Plan, the balanced relationship between the area's geologic formations, soil, and groundwater features is protected by the extensive canopy cover and root system of the forest, which shelters and stabilizes the hills and slopes. Activities which disturb this fragile relationship can substantially degrade resource values by causing landslide, flooding, erosion, and sedimentation. By stabilizing the soil and reducing runoff and erosion, the forest protects the community from landslides. Resources should be understood as interconnected, strands of complex ecological webs. The interconnectedness of the trees and the roles they play in this forest for absorbing water cannot be overstated, particularly because we live in a rainy climate. To clear-cut the trees does not protect them as a resource. It destroys them as a resource. The landslide cannot be engineered to never slide again. The development is proposed over an existing landslide. It's not if, it's when it will slide again. 17 families live uphill from the proposed area, the disturbance, and within the known landslide zone. The city should not allow 21 more families to be located in this zone. It's too much of a risk. The hearings officer approved this application is in error for the reasons I've stated. I ask you to overturn the hearing officer's decision. Thank you.
Very good. Thank you.
Carol spoke earlier, so we can probably go to the next three.
Very good. Thank you.
Next three are Roger Zumwalt, Linda Meyer, and Seth Dryden.
I'll try to pick that up.
And they'll be followed by Jim Hussey, Lee Cannon, and Scott Burns.
Do the slide.
Good afternoon.
Good afternoon. Roger Zumwalt. I'm a South Burlingame resident, and I'm going to try to pick up a couple pieces that just got cut short. First off, speaking to the PACE engineer, the last 2 points on his was that you made multiple inaccurate statements, which I don't know that that could be verified. I don't believe it was true. Second, I request you cease and desist in your efforts to misrepresent our development. Basically, he was threatened with a lawsuit, so he said, I'm not doing this because I'm not going to make enough money to bother covering this. So that's that part. Next up, we got a little bit of a sync in our slides here, but I think that speaking for Carol Hazard, these were the issues that have to do with what creates landslides, what triggers them in virtually all cases of the type ancient landslide stuff. So we're talking about not holding water, which you've heard, adding a load, putting heavy soil, more soil on there or fill, especially on steeper slopes. I mean, that's just physics. We all get that. I'll skip the next one and said, avoid excavating on or at the base of steep slopes. And that's a concern that will come up again in our conversation. But there's a nice graphic there that illustrates what's caused many slides in our city. So to my testimony, what you're basically going to see here is Three slides that follow, they're from Rivertech's geological report of January 2017, figures 1 and 3. It identifies an ancient landslide, and it shows the existing nearby homes in purple. Slide 1, I guess I just hit that. Slide 2 overlays the 2 with the development shown in red. Slide 3 shows that, sourced from their report, enlarges the landslide, and it highlights the landslides in brown, a light yellow, a gold, which is the beginning of the slope, which is called the headscarp, and then the red are slide activations that have happened in the last 150 years. So to call it ancient and it's never active is not an accurate description.
Is this in the record? This was submitted before?
This was submitted by the applicant.
Thank you.
Yes. Let's see. I would point out that in their geological report, they call 81 and 82 don't matter because they aren't being developed. And that's a pretty close call. 82, if you see it here, is right on the edge of, well, it's right on the edge of where one of the lots is placed. Then I would go to the bigger one in the center, 85, and you can see it just barely pokes in there, but the headscarp, the darker brown at the top, if that's where it started to break away. If it continues to break away, it touches several lots across the back. So I would say that this is landslide activity with no man-made disturbing influences. In fact, in this area, ancient landslides have reactivated here, and it looks safe or it's kind of okay is really not very reassuring. And we have 17 families that currently live on this landslide, and the development position is 21 people that are really at the risk of catastrophic harm, which has been already reported. And I would add that there are multiple examples, current and in recent history, of ancient landslides activating again.
Thank you, sir. Appreciate it. Good afternoon.
Good afternoon, Mayor, Commissioners. I'm Linda Meyer. My family lives on this landslide, and I am concerned for the safety of all families who also will live on this landslide into the future. My piece is to talk further about the Landslide Hazard Code. The code's purpose statement says that the approval must ensure there is limited risk of landslide recurrence. This has not been proven in the landslide hazard study, specifically as it relates to the problem of excess groundwater, which can trigger a landslide. The conclusion of that study states the development will not adversely impact Stevens Creek watershed or produce hazards to life safety. But after this, there is a very long limitation statement. It says, construction of the recommended drainage improvements for the groundwater problem associated with the project will serve to improve the overall slope stability of the site. It's our opinion that the risk of future slope instability in the development areas that have been modified by ancient landslide activity is low, assuming our design and construction recommendations are followed. The problem of groundwater is so significant that this report encumbers the conclusion statement with limitations that require mitigation for groundwater. What was the mitigation design? Trenches, to collect groundwater with the utilities and between the development and the upland neighborhood homes. But what happened next? This mitigation, the trenches, they were removed in July, and no other mitigation for groundwater was created. And the natural mitigation, the trees that use up the groundwater that's there now, will be gone. No statement is made as to why no new mitigation is needed or created to replace the trenches that were the design requirement for the assurance of low risk. We conclude that the removal of the mitigation for groundwater invalidates the statement of low risk. This finding invalidates their conclusion that the building of this development will not harm the environment or the people on the land. The hearings officer failed to notice or discuss any piece of this critical plan change that endangers the lives of all citizens who will live on this land into the future. He then erred by determining that the code for landslide hazard could be met. The decision should be overturned for this reason. Thank you.
Thank you. Good afternoon.
Afternoon. Mayor and City Council members, my name is Seth Dryden. I own the property that directly abuts lots 3 through 8, along with my wife and 2 children. As a third-generation Portlander, I am proud to call the City of Portland my home. As a homeowner whose home directly abuts the proposed Macadam Ridge subdivision, I feel compelled to speak about the landslide risk that puts my family in danger. I am here to specifically speak to the Portland City codes that were not applied to safeguard public and private interests. I feel the hearings officer did not provide an adequate review of materials before providing a narrative that served only one interested party. Other evidence points to the hearing officer not considering all the evidence in record. One example is that he did not reference evidence of a city-requested 2013 master's geology thesis overseen by landslide expert PhD Scott Burns that has studied the Stevens Creek watershed. Odenor never referenced the serious issues raised that the watershed, and this is a quote, the watershed is prone to slope failures if the soil becomes saturated. They are all likely to fail. As part of this thesis, an avoidance area map was generated for groundwater infiltration that advised neighbors to avoid soil saturation, which leads to slope failure. This avoidance area entirely encompasses Macadam Ridge. Additionally, the hearings officer's findings did not entertain evidence that the Portland West Hills are composed of Portland silt, and the Portland Southwest Hills Resource Protection Plan states on page 41, Portland Hills silt has important implications for land use and development. This silt becomes unstable when wet, and the potential for slope failure is particularly high after the winter rains have saturated the soil. Many sites in the Portland area have a known geology that is susceptible to landslides as well as steep slopes. Adding an abundant uncontrolled groundwater to the site further adds that risk. One of the slides that's been presented numerous times here is directly from a publication that is published by the Oregon and Washington state governments called the Homeowner's Guide for Landslides for Washington and Oregon. In that, you will see the water is heavy and pushes soil particles apart, which reduces the soil strength, increasing landslide risk. The same guide also states live tree roots strengthen slopes. I will remind you that over 500 trees are expected to be cleared as part of this plan. Plus, actually, I heard it was over 3,000 earlier. I believe the risk in this known landslide site is significant, and the hearing officer failed to apply the provided evidence in his findings, and there is insufficient water mitigation and did not address the applicant's changing approach throughout their application. We see the water clearly concentrated on the slopes, and we know there's a trigger for recurrent landslide. Water does not obey property lines. I believe Macadam Ridge application should be denied due to safety concerns not adequately addressed, appraised, or acknowledged by the hearings officer response, and I believe that my family's safety is at risk if this development is built as currently planned. Thanks.
Thank you. Appreciate it.
So, Mayor, may I ask Mr. Dryden and Ms. Hiller-Webb to address a couple of items? I've provided copies of the materials to the applicant, and they've identified some things that they're not sure in the record, and some of those relate to your testimony. So I just want to deal with those as they come because there's so many pieces of evidence. So the first, the slide that you showed with the saturated soil, wet soil, dry soil, you said that comes from a homeowner's guide?
That was put into evidence by me. It's Exhibit 29,
That's
each 29.
Okay. So each of those is from the same?
Or it might be 30, yeah.
Okay. Second, there are a number of pieces of factual information, Mr. Dryden, in your letter, so I can look at them, and you just read that as your testimony, related to damage to a number of homes during the 1996 floods, a statistic about 76% of the landslides. Is that information, that data, already in the record somewhere?
That was, I believe, an outdated document that you were provided there.
We can start that. We might have had clarity issues on that one when we included it, so I apologize for that.
Okay, I'm going to suggest that in Seth Dryden's February 7th, 2018 letter, the paragraph beginning in February 1996, continuing for the next 3 paragraphs with the sentence saying reduces soil strength and increasing landslide risk, I would request that that not be considered by council. We will consider that new evidence and reject that.
Without objection.
Okay, thank you.
Thank you for your testimony. We appreciate it.
Next 3 are Jim Hussey, Lee Cannon, and Scott Burns. and they'll be followed by Mike Andrews, Eliana Andrews, and Robin Harmon.
So, Mayor,
Yes.
I apologize. We're heading into a portion where I'm going to have a few comments. Before Mr.
That's fine.
Burns testifies, I'd like to have a bit of a discussion with the testifiers about what information is appropriate and what is not.
That's fine. Would you like us to take a 2-minute recess?
No, before he testifies, I want to talk, I don't know which of you is Scott Burns.
That's me.
You are. Maybe I could grab him for a moment and just.
That's fine. We'll start at the other end of the table, and we'll work our way down, and if you could just step over and chat with the legal counsel for a minute. Yeah, thanks. Good afternoon.
James Hussey. I've been a resident of the South Burlingame neighborhood for 15 years. I had planned to speak about the landslide risk and the water drainage problems, and how I felt that the House officer had not thoroughly addressed this, and that a hydrology report at least was needed. All the points I was really going to make, I think, have been covered now, so in an effort not to be redundant, I'll just end it there.
Very good, but you're on the record in support of these positions, so thank you for stating so. Good afternoon. Thank you.
Good afternoon. Thank you for hearing us today. My name is Lee Cannon. I'm a licensed insurance agent for over 20 years in the state of Oregon. I'm here to provide information regarding to coverage for a landslide loss for families within and adjacent to this development. Bottom line, it's going to be very difficult, if not impossible, for these families to secure landslide coverage for their homes.
Excuse me, has this previously been submitted
yes,
to the
this
record?
was submitted.
This was submitted in Linda Meyer's testimony.
Excellent, thank you.
Yes.
Thank you. You're brilliant.
Okay. So it's, forgive me there.
Sorry, and just so people know why we're being sticklers, it's just because this is a formal evidentiary hearing, and so it's very important that we get all these details knocked down. So sorry about that.
Not a problem. So it's important to understand that landslide is a risk that's not covered under a homeowner's policy. So when you have insurance and a loss with a landslide, it's not covered under the home policy that you get. It's not available for coverage under the federally backed FEMA policies for flood. Typically, the only coverage that's going to be available is what we refer to as a difference in conditions policy. The other options, forgive me here. The other option is looking at our state and local governments, which we're doing today, and that's through our building and ordinance codes and approval to decide beforehand to protect its citizens if this is a safe place to develop is really the only recourse, and that's why we're here today. So some of the difficulties that these folks are going to have in getting coverage for this particular area is that first, the homeowner is going to need to supply a self-paid for geotech report for each of their properties. These can be very expensive. This is required before they can even get a quote for coverage, and there's no guarantee that they'll receive a policy in such a case. Additionally, this area has been identified as a high-risk landslide area, and most of the carriers will not cover this. The carriers we're talking about essentially are surplus lines, not admitted carriers backed by Lloyd's of London. Next, the structures are often required to be built on firm and natural ground. In this particular development, they're looking at potentially 20 tons of fill material, which will essentially bar those coverages, those new developments from getting a landslide coverage. Should they somehow be offered a policy, we're looking at tremendously high premiums, very high deductibles, and very limited coverage. So bottom line, the homes that are newly constructed and adjacent to this property are going to have a very difficult time in getting coverage. Ultimately, when there is a loss, the homeowner is going to be left to face a lopsided battle against developers, engineers, and contractors, assuming they're still in business. And ultimately, it's you, the City of Portland, and we, the taxpayers, that are going to be looking at defending these costs and claims. That's why, in looking at today, we have a time through supporting this appeal to go ahead and protect those citizens. I want to take the rest of my time and introduce Scott Burns, who's a PhD chair in geology and professor emeritus at the Portland State University. He's worked in the field of geology for 47 years, 35 of which specializing in landslide and training geologists in this area. He's examined most of the significant slides in the Northwest, and he is broadly considered the foremost expert nationally and often appearing as an expert witness in landslide cases. Professor Burns has voluntarily offered his testimony as a demonstrating expert after reviewing the evidence in this case. His motivation is appearing for this egregious to defend those for this area so that we don't develop homes in this area to have families.
Thank you.
Go ahead.
Appreciate your testimony. Good afternoon, sir.
Good afternoon, Mayor Ted and the rest of the council. Scott Burns, engineering geologist at Portland State. What does an engineering geologist do? Site evaluation is the heart of everything that we do. Before you build something, you want to know if there's going to be any geological problems, especially hazards. I led the team that mapped those 705 landslides that was mentioned earlier here, and last winter I visited 66 landslides here in the Portland area. And I'm not paid for this. I do this as reaching out, and I'm a free consultant for the city of Portland on anything to do with slope stability. I'm going to be focusing in primarily on the landslide and reactivation of the ancient landslide, which has been mentioned a lot before. This landslide is a big one. The scarp is 50 feet high. It's one of the biggest ancient landslides that we have in the city of Portland. And there are 9 houses that are actually on the landslide that are built right now. The project that is coming up, 21 additional ones. If that particular landslide reactivates, what will happen is those houses will be moving. It's not going to be like an OSO and a catastrophic one, loss of life, but the infrastructure is going to be hurt. One of the bottom lines that I talk about over and over and over again, landslides are not covered by insurance. And so those houses will lose if it starts moving, and then the 9 houses that are already on the landslide will also be a major concern. What's going to happen is it'll go to lawsuits. Who's going to get sued? The city of Portland and the developer. And my 35 years of research in the Pacific Northwest, one of my major important things that I've come up to the conclusion is building on old landslides because of the potential for reactivation later on. What are the 2 things that are going to make a landslide reactivate? They've been mentioned before: high water input and then earthquakes. We have the big one. The last one was 318 years ago. When we had the one 1964 up in Alaska, Turtigan Heights, 70 houses moved down as a result of that earthquake. And then in the Pacific Northwest, we have many examples. And so if you want to know some of those examples, I will mention them because they are very important. Each one of those, the geotechnical report that came in before said this is stable. But it's the extreme events that we are not prepared for. Number 1, huge rainfall events. And as the climate is changing, we're getting more of those. Secondly, the earthquakes. Are we prepared for that? And so as a result, those are some of the things that I wanted to mention there. I have read the report of the particular site. I know that 2 engineering geologists, geotechnical engineers, they are very, very qualified. So that was a very good report for what they had to do. I have concerns about putting 20,000 cubic yards of fill on there and then removal of all those trees. A tree is a natural pump. It is pulling water out of the ground and therefore increasing slope stabilization. Thank you.
Thank you, sir. Appreciate all 3 of you.
So before that group leaves the table.
Yeah. Sorry. Wait.
Mr. Cannon in particular, could you address, and I'm sorry, I'm pretty sure everyone's really annoyed with me, but this is a really challenging record trying to understand.
No, we all get it. No worries.
Mr. Cannon, in terms of the insurance information, the applicant is not aware that the information about homeowners insurance, so in your letter from the 2nd paragraph, basically through the end, that information is not in the record about insurance. Can you identify if that information has been placed in the record before?
Linda, do you want to speak to that?
I think it's in Linda's.
It's Linda's.
It's in Linda's letter.
Can you come to the microphone, please, so that the captioners can get it? Thank you.
That's included in my letter of November 5th, which I believe is 95.
Okay. Did you include evidence regarding the specific difference in condition policy?
Yes, I did.
Okay. Let's see. In terms of Mr. Burns' testimony, I think council, I would be very surprised if there was information in their evidence that Mr. Burns had made a statement about the quality of the engineers for the applicant. I would assume we should strike that, unless anybody's telling me that information is in the record. Okay. You did not go into any of the sites, the other pieces. The applicant, did you note anything else in there that would have been new information from Mr. Burns' testimony, or do you want to address that during your?
Could you come to the microphone, please?
If you wouldn't mind identifying yourself, sorry. Thank you.
Commissioner Fritz and Mayor Wheeler, Chris Kobach, I represent the applicant. On Mr. Burns' testimony, he's made a couple statements like the city has no liability and our experts are qualified. I think those are the same. So I just think they should be treated the same. I mean, if it's all coming in, I don't really object to it, but I don't think you should cut out some and keep the other stuff.
Okay. When we prepare findings, we'll just make sure we are consistent in treatment of that piece of information. Thank you.
Good. All right. Thank you for clarifying that. Next three, please.
Are Mike Andrews, Eliana Andrews, and Robin Harmon, and they'll be followed by Robin Besse, Fred Hazard, and Mary Holderness.
Good afternoon. Would you like to start, sir?
Yes.
Thank you.
Good afternoon, Mayor and Commissioners. It's a pleasure to speak before you today, and I appreciate your time. My name is Mike Andrews. I'm a resident of South Burlingame since 2001. The Macadam Ridge development should not be considered for approval at this time. The development proposes an increase in housing density on lots smaller than the R10 standard, minimal 10-foot front yards, and razor-thin side yard setbacks, with nearly identical 40 by 40-foot building pads, with a probable building height of 30 feet. And I want to reference one of the documents from the consultant that states, building size is anticipated to be similar to the closest neighborhood lots on Ruby Terrace of about 2,800 to 3,000 square feet. How's my mic coming through? It seems like it's cutting out.
Yeah,
okay.
it's fine.
With limited time, I will focus primarily on two environmental modification concerns, minimum lot area and side yard setback. Zoning for the proposed Macadam Ridge development is R10C. See the zoning exhibit and preliminary site plan 4A. The subdivision is closest to the houses on Southwest Ruby Terrace to the west, and within the South Burlingame neighborhood zoned R10.
Could I make a request? Just shove the mic about 6 inches away. It's really sensitive, and there you go. Perfect. That's perfect right there.
The subdivision is closest to the houses along Southwest Ruby Terrace to the west, and within the South Burlingame neighborhood zoned R10, illustrated in light yellow highlight. To the north is the South Portland neighborhood, which is also zoned R10C, where existing housing abut the proposed development. This proposed development is closest to the houses along Southwest Ruby Terrace within the South Burlingame neighborhood, and include 10-foot side yard setbacks and 10,000 square foot lots. The R10 zoning is located to the south of the development. Both neighborhoods have R5 zoning. However, this zoning is much further away from the proposed development than the abutting houses in the R10 zone. The greater the housing density, the greater the subsequent impact to the environment, including trees and the existing landslide area. As a refresher, R10 zones have a minimum lot dimension of 6,000 square feet. The proposed development is pursuing 14 lots below the R10 standard. The staff reports that adjacent properties nearby to this development are R5, and that is not correct. It's R10. The nearby and closest properties are along Southwest Ruby Terrace. Smaller lots are not the only way to reduce the possible impacts to the permanent project resources, protected resources. This can be accomplished by simply reducing the number of proposed lots for the entire development and increase space between buildings. Additional testimony has been provided, and I won't be able to get to it.
Very good. Thank you. Good afternoon.
Afternoon. Good afternoon, Mayor and Commissioners. Thank you for letting me speak today. My name is Eliana Andrews, and I live in the South Burlingame neighborhood. I'm a student at Lincoln High School, and I am 15 years old. I was born and raised in Portland, Oregon, and I love trees and the environment. I will be speaking today about the lack of required street trees on this project. I'm requesting that the McAdam Ridge development not be considered for approval due to the failure to comply with the City Code Title 11. I'm concerned with the proposed development and the lack of required street trees in the right-of-way near lots 3 through 11 and lots 15 through 20. The way it is currently designed, there are engineered stormwater planter boxes instead of planting area for street trees. So you can see the exhibit. Site Plan 4A does not provide adequate quantities of street trees on public street A. The street tree standards require street trees in the right-of-way for each full increment of 25 linear feet per side of street. Based off this requirement, there should be an additional 36 street trees and adequate planting area to accommodate their growth. Design 4A has not addressed the requirement for street tree planting, and the engineer had the opportunity to do so. This design should have been coordinated with the urban forester, but it was not. Nothing in the record demonstrates that the applicant or the project arborist consulted with the urban forestry staff regarding the options for the right-of-way design. Street trees not only make the street more livable, but will reduce the stormwater discharge and soften the vertical buildings. With the reduced front yards to 10 feet and public utility easement contained within them, adequate planting space is not available to allow the homeowners to plant significant trees in their property. The lack of adequate planting area in the private front yards strengthens the argument requiring street trees in the right-of-way. On a separate but familiar note, I am very sad and very discouraged to hear that about 500 trees are intended to be removed from the site. This property is located almost entirely within a protected conservation zone. The removal of so many trees indicates that the engineer was not sensitive to the site and did not find a creative approach to take the existing trees into consideration. This proposed subdivision should not be approved as designed. Thank you for listening to my concerns.
Thank you very much for your testimony. Well done.
Ms. Andrews, I just have to say, I don't often get schooled on land use cases, and I had not noticed that point, so well done.
Thank you.
Good afternoon.
Good afternoon. My name is Robin Harmon, Mayor, Commissioners. My husband and I have lived in Portland for 16 years. I know a little bit about land use because I got involved with the Residential Landfill Committee project. I went to the first meeting, and then I went to them all. I was called the 27th member of the committee. So I'm aware that there are often conflicting needs between owners, residents, and preservation. But I'm here today because this property has unique and irreplaceable value. Allowing this subdivision would endanger current and future residents and destroy the precious, critical natural resources that is vital to all of our well-being. Our neighborhood recognizes the need to keep pace with the growth of our city, and we welcome new neighbors. However, we also want to ensure that safety is a major consideration, as well as protection of our dwindling natural resources. As you know, city codes were established to protect the qualities that make our neighborhoods desirable and our city great. We ask that you adhere to those codes. These ordinances are for the collective good of our city. We are united in our defense of protecting valuable resources and safety. We've spent our time, our expertise, and our resources in this cause because we believe that we have a responsibility to stand up for what is right. The hearing officer's decision is flawed. He made a decision with conditions, which implies that burden of proof has not been met by the applicant. After 4 years, a consensus has not been reached, and the officer has deferred to the bureaus again, who have maintained they lack the necessary information from the applicant to make a determination. Odenor's decision lacked analysis and provides no clear definition of why he gave approval. Page 9 of the decision references neighborhood review, in which 9 written responses have been received in support of the proposal. The next sentence reads, letters were also received from SBNA and Collins View associations. After spending 4 years of dedicated effort, it was offensive to us that he made no mention of our opposition and no reference to the 56 letters received, nor the experts hired to offer their opinions. To that end, we are in support of accepted principles that define smart and balanced growth, mixed land uses, advantage of compact building designs, walkable neighborhoods, preserve open space, farmland, natural beauty, and critical environmental areas, and encourage community and stakeholder collaboration in development of decisions. That means not a dog and pony show, but listening critically to the concerns of neighbors and not having a deaf ear to it. We strongly recommend the City Council deny the application. Thank you very much.
Thank you. Thanks all three of you. Next three, please.
Are Robin Vesey, Fred Hazard, and Mary Holderness.
This is the conclusion of SBNA's presentation, though.
And they'll be followed by Pat Dennis, Jay Jones II, and Carol Porto.
Good afternoon.
Good afternoon, Mayor Wheeler, City Council. I'm Robin Vesey. I actually live north of this proposed development on Canby Street. Most of my yard is a conservation zone, some of it a protected zone. Although I agree with all the points that have been made thus far, I'd just like to give you a little history about the City of Portland identifying Stevens Creek that traverses this area as a significantly threatened and degraded waterway due to untreated runoff from impervious surfaces upstream. 40% of the Stevens Creek subwatershed is covered by impervious hard surfaces, where runoff can lead to increased erosion, damage to the stream bed and its function, destruction of native species habitat, and additional pollution load on the Willamette River. Reducing the impact of this urban runoff is key to developing a healthy watershed. In 2004, the City of Portland identified protection of watershed areas with the highest remaining function and value as a cornerstone for effective watershed management and identified the Stevens Creek as an area worth protecting. In March 2006, the City Council adopted the Portland Watershed Management Plan to address these issues by identifying watershed health goals. It's because of this large development that there would be more associated hard surfaces and that would not be compatible with Portland's goals. I ask you to overturn the hearings officers.
Thank you. Good afternoon.
Good afternoon, Mayor and Council. I'm a 50-year resident of Portland, and I ask that you do not allow for the building of this critical piece of natural land in our city. I ask that you deny the application. Thank you very much.
Ah, the beauty of brevity.
Yeah.
To the point, no mistaking your position.
Absolutely.
Sir, put your name in the record if you would.
I'm sorry, my name is Fred Hazard.
Good afternoon.
I'm Mary Holderness. I live in South Burlingame. I'm also worried about the landslide risk and harm to the environment from this potential development. Please reverse the hearings officer ruling and deny the application. Thank you.
Thank you. Next three, please. That's it.
Are Pat Dennis, Jay Jones II, and Carol Porto. And they'll be followed by Bob Solinger, Sydney Villanueva, and Brendan Appleberry.
Good afternoon.
Good afternoon, Mayor Wheeler and Commissioners. My name is Patricia Dennis, and I live in the South Burlingame area. I agree with the speakers today who are asking you to reverse the ruling of the hearings officer. I also ask that you deny the application. Thank you for hearing us.
Thank you for being here. Good afternoon.
Hey there, my name is Jay Jones. I also live in South Burlingame on Ruby Terrace. I support everything that my friends and neighbors have attested to, and I would hope that you would approve our appeal and deny the applicant.
Very good, thank you. Good afternoon.
Good afternoon. My name is Carol Porto. Me too. I volunteer and live in Portland. I serve as the Southwest Neighborhood Secretary. I'm the chairperson of the Public Safety Committee for Southwest Neighborhoods. and I'm on the South Burlingame Board, and one of Marilee's assistant team leaders on our NET team. So we have an active group of citizens who really care about Southwest Portland and South Burlingame and about our safety and livability. So please support the appeal and deny the application. Thank you.
Thank you. Thanks, all three of you.
The next three are Bob Solinger, Sydney Villanueva, and Brendan Appleberry. And then the last two will be John Lavielle and Maria Baker.
Good afternoon.
Good afternoon, Mayor. Commissioners, thank you for your opportunity. My name is Sydney Villanueva. I'm a resident of Burlingame, South Burlingame as well. It seems that I may be the newest resident from today's testimony. And as I was sitting here, it occurred to me that I might be more reflective of the neighbors that are going to be moving into this area than the neighbors that I'm hearing and sharing concerns with today. So as you guys consider this application today, I just really would urge that you consider young families like mine moving into this area. I live up on 4th Avenue, which is a bit higher. We do have sidewalks starting on 4th, but the neighborhood within South Burlingame is not walkable. Sidewalks start and stop. And one thing that I haven't heard addressed today, and I apologize if it's new evidence, but really I'm just asking that you consider it, is that the traffic coming from both Terwilliger and Taylor's Ferry into South Burlingame is very aggressive. People are trying to beat that traffic during commuter times, and it makes for a very unsafe area for small toddlers like my son to be out and about. And that's something that this new neighborhood I think would be inflicted with as well. It was only a few weeks ago as I was driving down South Taylor's Ferry, I actually had to stop in the Riverview, turn around and come back and pick up literally a grandma carrying her toddler, grandchild up the street because there's no sidewalk and it's not safe for that kind of transportation. So as you review this record, I just urge that you consider it's not just are the boxes checked, but is this going to be safe for people like me and my young family?
Thank you for your testimony. Good afternoon.
Good afternoon. Sorry, I'm out of breath. Just ran to pay my meter.
Thank you.
You need some 3-hour meters on City Hall. So my name is Bob Solinger. I'm the Conservation Director for the Audubon Society of Portland, and we are here today to support the appeal and urge you to overturn the ruling of the hearings officer. As you're well aware, this is an important natural resource site. It's part of the West Side Wildlife Corridor. Amazing number of trees on it, steep slopes, earthquake risk, stream corridors. It's a site that we need to take the environmental codes very seriously on. And from our perspective, the hearings officer failed on that and basically ignored the environmental concerns that were raised. The appeal failed to meet the requirement that the development minimize the impacts on natural resources in an environmental zone. We feel that there were other alternatives that they could have developed that would have had less impact and met their needs. The hearings officer also ignored BES concerns that the plan did not meet the level of engineering specificity that's required for an environmental review, specifically regarding stormwater facilities, outfall modifications, sewer pipes, storm pipes, and a new outfall on Riverview Creek. Basically, he substituted his own opinion for the expertise of your own expert bureaus, and we think that's a really bad precedent. We think it's important that when you have technical experts at your bureaus that weigh in, raise concerns, and say they don't even have the information they need in order to make a real assessment, that the hearings officer should have required them to go back and get it right. So we urge you to support the appeal and to reverse the hearings officer. Thank you.
Thank you, sir. Thanks, both of you.
Was there a Brendan Appleberry? Then the last two will be John Lavielle and Maria Baker.
Good afternoon.
Good afternoon. My name is Maria Baker. I live on the east side, and I'm here today to support my South Burlingame neighbors. I'm very concerned about this project, and I think it was a mistake to approve it. I don't think that the hearings officer approved a project that reasonably limited the risk of landslides. And I don't know if this is new information, but I did a couple months ago call my personal insurance company of 20 years to ask if I were to buy a piece of property up on this hill in a high-risk landslide area, could you offer me some insurance? And the insurance company said, sure, it's under earthquake insurance. And I just said, no, not an earthquake, just lots of water. And maybe if my house was built on infill or whatever. And they said they didn't, but they could try and refer me to some special, unique, independent group that would give me like an individualized plan. And so I think that's unreasonable to expect families to take the burden of this risk. And I would like to protect them now, prevent it.
Very good.
Thank you for being here.
Thank you. Good afternoon, sir.
Good afternoon. My name is John Lavelle, and I'm a owned property and a resident of the South Burlingame neighborhood. And I'm not going to talk about the landslides and those types of issues that the other neighbors have talked so eloquently about. All I can say is when land's been denuded and the trees are gone, we only need to look to our neighbors in Southern California to see what happens when the heavy rains come. We've talked a lot about access to the property and increased traffic, and we've talked mainly about Taylor's Ferry Road and the dangers there and the dangers of sight lines and not being able to see up and down the street. I'd like to just talk a minute about internally within the neighborhood we call South Burlingame. I have a pretty good perspective because I live on a corner where 5 streets intersect. One of those streets is Ruby Terrace. Ruby Terrace is the main street that will provide access to this development outside of a Taylor's Ferry. Ruby Terrace, the street is narrow. It would probably be substandard today. It's in bad shape. If 2 cars are parked opposite each other, it's difficult to get another car to be able to pass through them, let alone a larger vehicle like a fire truck. In fact, Ruby Terrace was in such bad shape that a group of the neighbors banded together and repaved it at its own expense because the city couldn't get around to repaving it because the street was falling apart. So I'd like the council to consider the impact on the neighborhood itself of these additional vehicles, the wear and tear they're going to cause on the street. And the streets are already overburdened and stressed, and the effect that's going to have on the people that live there with the additional traffic that's going to come with this development.
Thank you, sir.
Thank you.
Thank you both. And that is it for public testimony on the supporters of the appeal. So next up is the principal opponent. You have 15 minutes, sir. And again, if we interrupt with questions, that does not count towards your time.
Your Honorable Mayor, Commissioners, my name is Chris Koback again, and I represent the applicant, Riverview Abbey Mausoleum Company. I only get to speak once. The appellants get to address you again. And so, the only thing I'd request is if you have questions or comments on my presentation, I'd really appreciate it if I could answer them while I'm here, because once I sit down, like I said, I don't get another opportunity. Mayor Wheeler, you said something about how if everybody in one of these proceedings agreed, it wouldn't necessarily be a good thing. And as you might expect, my clients view this proposal from a different perspective than what you've heard. The environmental regulations, the purpose is to protect the environmental features on a site to the extent reasonably practicable, but allow environmentally sensitive urban development. My clients started out with a proposal that they felt was consistent with all of the regulations. And in the staff report from October 6th, staff commented that the basic approach was consistent. Staff did need details, and there were questions in the staff report and comments where staff wanted details to show how the proposal could be brought fully into compliance. And over the course of a couple of months, my client worked very, very hard to provide all of that detail. And they arrived at a final proposal that was approved that I believe, and my clients believe, is a good example of a very responsible, sensitive development. And I wanted to list a few elements of it. So the site is 14.2 acres, and it has what our consultants identified as 3 most significant resources, and that's Stevens Creek, and others have talked about that. There's Ruby Creek, and then there's a mature forest. Our consultants found that
1/3 northern portion of the site had the best habitat for the reasons you heard, that it provides an added enhancement to the other resources. The proposal, after considering 12 alternatives, and that's in the record at Exhibit H100B, or no, it's 107N, 12 alternatives, some of which had different access points, different housing types. Alternative 5 was a multi-family development. Our proposal restricted development to a 4-acre portion of the site that is the most flat portion of the site. It's the area that any development of this property would have to go to given the significant resources. The proposal preserves the rest of the site, 10 acres, in a permanent protection tract, and it's been offered to the city for free. My clients have offered to donate that. They've reduced their proposal to 21 lots. Now, the maximum density is 52 on this site, so they're at roughly 40% of that already. The total disturbance area you've heard, it's a little over 29%, 70% is undisturbed. We have about 72% of the lots are below the minimum lot size, and my client had to process an application to get that. And that was encouraged by staff and supported by staff, because by moving to reduce the lot size, we could put the lots on less and less property, and that was one of the goals of the proposal. There is no permanent disturbance in any of the resource areas, the significant resource areas outside of this 4 acres. There's a limited temporary disturbance, and some of that's real important because there's a failing stormwater outfall at Ruby Creek. It's not my client's outfall, but our proposal has that being rebuilt. There's a failing sanitary sewer line that's right in Ruby Creek, and BES has acknowledged it's failing, and it's not a good thing. Our proposal removes 2/3 of that at our expense, routes it through the development with a new system, and back connecting. So 2/3 of it will be new and never have to be worried about at all. Our proposal is to remove over the site, entire site, significant invasive non-native species of plants, enhancing what's already there as a valuable resource. The mitigation is extensive. There's over 12,300 trees and other plants that are being planted. And that's in addition to preserving 1,400 trees. So it is true, 470 trees approximately will be removed in the development area, the disturbance area. But 1,400 trees across the site are being preserved. That's 70%. Now, the code has a requirement to preserve 35%. So this proposal preserves 70%, and that's in the staff report as well. It provides.
I just need to get a clarification there. What do you mean the code requires 35%?
Well, what staff said is the basic requirement for tree preservation on a site is 35% under the code, and this proposal preserves 70%. Now, this proposal has to be viewed in a little bit different light because it's in an environmental zone, so we have that added layer where we have to do a little bit more, which I believe we've done.
Yes, so the 35% is not applicable, right?
Well, no, it's applicable, but I think it's overridden by our need to do the alternatives and come up with the best proposal to preserve the resources that's practicable.
Right, thank you.
As was mentioned, there's the Hume Street right-of-way is already there, and that's where the 54-inch tree is. It's directly in that right-of-way. It's an existing right-of-way. Our proposal has that being improved as connectivity to Ruby Terrace, and that provides a secondary emergency access for fire and ambulances to get to the neighborhood to the west. We are building a TriMet bus stop at the request of TriMet. We asked them, what improvements do you feel are necessary? TriMet's email's in the record, and TriMet concluded that based on the very limited ridership, off-site sidewalks all the way to the bus stop are not necessary, and they didn't recommend them. They recommended a new bus stop, and it's either going to be where the existing one is or part of our frontage improvements. And we've agreed to do it wherever TriMet wants it done. And lastly, this provides 21 homes for families in Portland, and homes are needed. I want to talk a little bit about how we got here. Through this process, all of this information that was coming in and responding to staff, neighbor testimony was coming in, it all went to a hearings officer that the commission retained to make important land use decisions like this. Now, he's now no longer a hearings officer. He was appointed to the bench recently, but the Honorable Mr. Odenor, he evaluated the evidence in a process that is sanctioned by state law in your code. He followed the procedures in ORS 197763, which is an evidentiary process where the parties are, that's the purpose, is to present new evidence. And we've pointed out in our written material that the number of documents, the pages we submitted, is grossly overstated. At one point, somebody said 500 documents at the hearing. It was closer to 200 documents, but 96 of those were, there's 2 land use decisions that were given to the neighborhood association 2 years before that. So there was some new information at the hearing, but it was not nearly as extensive. Mr. Odenor gave everybody a fair and equal opportunity to present evidence, and the appellants requested an open record period. He granted that, and they were allowed to submit evidence. He even gave them an extra period to submit new testimony. If you read his decision, and I'm sure you likely have read it, the hearings officer carefully considered the evidence. He recited in his decision on 6 pages, 13 through 17, he talked about all the alternatives the applicant had submitted, alternative development plans, in some detail. He addressed the issue over lots 3 through 8 and why it was appropriate to preserve 34 mature trees there because they were valuable resources, and why it was acceptable to put those under a deed restriction. And that area also provided transition between the neighbors, and many of the neighbors testified at the hearing that they supported that. He detailed on pages 23 through 29 the final disturbance area. And I want to talk about that because it is not as if the final disturbance area is not known to reasonable particularity. As of November 6th, the layout was done, the streets were done. Nobody, even the bureaus, were suggesting that the internal streets or the lots were going to be reconfigured at all. There was an issue about from the BES on the red line of a concept drawing. The conceptual development for the stormwater facilities go through reviews. BES redlined the first one, we responded. Right during the hearing process, towards the end, BES gave a second red line version, and it tweaked the size of the swales on the street going through the development, Street A, such that BES said you may need to build another stormwater facility, a general one at the end of the cul-de-sac. Our experts jumped on that, and they designed that swale, if it's needed, and it would add 1,300 square feet of disturbance area. And then significantly, all of our other experts, the environmental consultant, who determined the resources that would have to be mitigated for, and our arborist who defined the disturbance area, they submitted updated drawings. That was all known. Before that, they had also updated their drawings to increase the disturbance area for the reconstruction of the outfalls, as staff had suggested. So we added 30 feet of disturbance area, but all of the other documents that go along with that to show how that was mitigated for, they were all updated as well. So at that time, until BES made that statement, the disturbance area was done. And what's left is the final approval of those BES drawings and those swales. And it may moderately, even modestly, increase the disturbance area. But there's going to be a technical review of plans, and there are conditions to cover that. It's not as if this proposal is going to change and the disturbance area is going to go from 29% to 50%. Given everything in the record, and if you examine that evidence, I think you'd conclude that it may increase slightly more than 29%, but still stay under 30%.
Could I ask you a clarifying question? So that's the disturbance of the total site?
Yes, that's the final disturbance area for the development.
Okay, and can you tell me how much of the disturbance area is in this landslide area that's been discussed and that is in the record?
Well, I believe most or all of it. Most of the site is in a landslide area. Okay. And that's what I was going to talk about, Your Honor, is...
Very good.
There was a question, even staff mentioned this, Commissioner Fish asked the question, how does the landslide regulations work? Well, they work like this. When you're in a landslide, and there's a lot of areas in Portland are, you have to submit informed studies for the city to evaluate before you develop. You have to establish through expert reports that it's reasonably safe to do that. And in the decision, the hearings officer notes 4 different reports that the applicant put in. The last one was a supplemental slope stability analysis. All of those reports went in, and the city's experts in site development reviewed them, and their conclusion that I recited in my written material, they concluded that that was an acceptable response under the code. Those are experts. Now, concerns about landslide, I'm not diminishing the concerns that neighbors have, but the code has a process for how that is handled, and concerns without expert analysis are just concerns. We followed the code and submitted what was required, and the city experts viewed it and felt it was sufficient. The other thing I want to talk about, because I'm running out of time, is the transportation. One of the testifiers earlier said it wasn't proportionate. The offsite impacts doing all of these improvements along Taylor's Ferry was not proportionate, and that's right. Even transportation staff didn't find it proportionate. But everything that you've heard about the transportation issue are existing conditions. Nobody is denying that Taylor's Ferry, cars go fast, and there's a lot of cars. Nobody's denying that there are safety issues on Taylor's Ferry. But the requirement that the hearings officer looked at is, to what level can I go to expect a private owner to improve an existing problem? I have to find that their impacts create the problem. And I think he absolutely applied the constitutional law correctly and found that the improvements, the frontage improvements that the city required were appropriate. They're on our frontage. The TriMet safety to transit or access to transit was acceptable, but he agreed that he could not in his decision require massive off-site improvements along an existing stretch of highway to account for existing issues that have been there for many, many years. I do want to talk briefly about the conditions because I think they're important. The conditions, there's numerous conditions to assure compliance. A lot of them go to this final disturbance area. There are technical reviews required in those conditions. And it's important, I think, to note that those conditions, other than a couple that the hearings officer imposed on his own, came from staff. BES said, if this is approved, these are the conditions we want, and they're technical in nature, and they're in the notice of the hearing here. Those are in the decision. We proposed them. Transportation recommended conditions. We included them. Site development proposed conditions. We recommended them in our final submission. Those conditions are, if you read them, and I think you will, they are very technical. They're consistent with all other approvals that go through this process, and they will ensure compliance with the criteria. Now, I did want to mention one thing because the tree issue, I know that the tree issue was addressed. In the staff report on page 37, staff lists those technical requirements that come later. And when you get a building permit, you need to have the street trees addressed. They're called, on page 7, they're referred to by the city as other technical requirements.
Commissioner Fish would like to ask you a couple of questions.
Mr. Kobach, you're about to run out of time, and my colleagues may also have questions, but and I appreciate your presentation. There was something in the appellant's presentation that troubled me a little bit, and I wanted, in fairness, to give you a chance to address it. And that was the communication between Steve Griffith, who is the applicant/owner, and someone who was being considered as a consultant. There were two things about that communication that struck me as odd. One was it was a communication from the owner and not you as his representative. And the second is, I think any reasonable reading of that communication was there was an implied threat. That's now been placed before us. It may or may not be material to whatever decision we make, but in fairness, I wanted to give you a chance to respond to it.
Well, I didn't author it. It wasn't done at my direction, I can assure you. Mr. Griffith is here. He's one of the people that will testify, and I think he can give you a better firsthand version of why he wrote that. I can tell you he was concerned that false statements were being made about the proposal and his experts' work, and he didn't think it was appropriate for somebody to make those statements.
And you understand why, in terms of just playing referee in this process, that would be of concern to us?
I do. It is a concern. Mr. Griffith can explain it, but I don't believe it was intended as a threat. I think it was intended to more or less, in Mr. Griffith's standpoint, level the playing field.
Well, I think it's open to interpretation, and I think that's one of the problems, because it's an unusual document, and it's not something we typically see in these kinds of land use hearings, and it apparently caused someone not to provide professional services, and that again, serving just as the referee here and not the decider, that troubles me a little bit. But my second question to you is, if the council determines that the appellant's issues have merit, obviously a couple things might happen. Number one, you could appeal this decision forward. Or number two, I suppose you could go back to square one. In the conversations that you've had with the abutting neighbors and the neighborhood association and interested parties, have you determined whether there is an alternative that might be more acceptable to the community?
My perception is there will be no proposal that it will be deemed acceptable other than no development. The 12 proposals in the exhibit that I referenced, there's a narrative explaining how those were presented to the neighborhood association. So the neighborhood association didn't want a different access point. They didn't want multifamily, but then in opposing our approval, they now argue that we should have considered multifamily, which we did. At one point, we had very small, a PUD, alternative 5, small, very small lots. The neighborhood association didn't support that. And then later in the approval process, they claimed we should have done small lots. They're saying we want large lots, but then—
So you're skeptical of that. But then my final question is, you heard from Mr. Salinger that this is not only part of a West Side View corridor, which is of great significance, dating back 100 years, actually, to the Olmsteds, but it also is a heavily protected piece of property, as evidenced by the environmental zoning. Is it your view that if the ultimate resolution of this was the land could not be properly developed under the applicable law, that would be such an extreme measure that it would constitute a taking?
I believe under Oregon law that would. The test is if you're deprived of all viable economic use of the property, and if it can't be developed, there is no viable economic use.
Okay, thank you, sir.
Commissioner Fritz?
I would just have to say to that point that just one house is allowed under Oregon law, and that would be allowed use. So that brings me to my question, which I asked the staff. How did your client determine what was practicable?
Well, there were a number of things, and Mr. Griffith, I think, will expand on this, but it's a large tract of land. It's very expensive to prepare for development. They can tell you what it took so far. They've held it since 1945, paying taxes on it. I think their proposal proves that this is not just about maximizing lots and money, because they removed 2 lots in the process and created a scenic tract out of them. But there's certainly some point at which it doesn't make economic sense to develop.
And the evidence we saw about the disturbance area, the 4 alternatives that were considered seriously looked like very much similar disturbance area. Were the other 8 that I don't have in front of me, were they significantly different?
Very different.
And at what point were those entered into the record and considered by the hearings officer?
They were provided to staff before the hearing in late October. So they were provided to staff before the hearing.
And the neighborhood and the hearings officer both got to look at all 12 of them?
Yes, the hearings officer on pages 13 through 17 discussed them in some detail.
Thank you.
Could I ask a question with regard to the safety question that you raised in your testimony?
Absolutely.
And I just want to have clarity on your view of what the process is. So you had said that you did not feel that it was appropriate under this process to hold your client accountable for existing safety issues, and you stipulated that the road has a number of safety issues. So from your perspective, if this council came to the conclusion that adding this development would increase those safety issues, you do not believe that is something that we can take into account as part of these proceedings. Is that a correct interpretation?
No, Your Honor. I think if there's evidence in the record that the impacts of the development create safety issues, new safety issues on top of what's already there, that could be the basis for a decision to require mitigation for those specific impacts that you believe the evidence supports. The evidence is that there's a 0.07% increase in traffic on Terwilliger from this development. That was a big part of the evidence we relied upon to argue that the massive improvements that PBOT was asking for were highly disproportionate. 0.07% increase against millions of dollars of offsite improvements to address largely problems, maybe all problems that are already there.
Commissioner Fritz.
Thank you for pointing me to pages 14 and through 17 about the alternatives analysis. The hearings officer says that number 5 to 11 alternatives below were also carefully considered, but ultimately considered not practicable for a number of reasons. But then the hearings officer says, however, very little information is provided regarding options 5 through 11, aside from the number of lots. So I'm just questioning how much how much discussion was there of the alternatives? Because as I said before, the 4 that were really looked into in depth had almost exactly the same disturbance area.
After he said that, if you continue to read the decision, he then discussed a lot of details about those alternatives, and where he obtained that information is there is a specific exhibit as part of Exhibit 107N where each of the particulars of the alternatives that were considered were described, and the decision process for not pursuing them was set forth. So there was a lot of evidence in the record on what process the applicant went through to evaluate those, including meeting with staff and getting staff input and meeting with the neighbors.
Did any of them have these Hume Street moved so that it avoided the 54-inch tree?
Some of them had a different access point off Front Street, which is another right-of-way that intersects more perpendicular with Taylor's Ferry. And there were significant issues that staff identified, as well as the applicant, grading and other issues, that prevented that from being used. So Hume Street was ultimately settled upon as the appropriate right-of-way to improve, to connect to the other neighborhood and to provide access to the development. But yes, other access points were considered, and if the alternatives are all there. You can see some of them would not have impacted the tree. There were efforts made to avoid the tree, and because that right-of-way is the only practicable way to get access, and the tree is in the existing right-of-way, the arborist looked at it and said, there really isn't a way to save the tree and put a road in.
Thank you.
Mr. Mayor, I just have one additional question.
Mr.
Kobach, what if the consultants that you retained are wrong and there simply is no way to adequately mitigate against the risk of landslides?
Well, if they're wrong, the conclusion, there's a lot of things they said, but if they're wrong on their ultimate conclusion that this can be developed safely as long as their recommendations are followed, then the conclusion you would have to draw is it likely can't be developed safely. But there's no evidence in the record to contradict their reports. The only evidence of anybody reviewing them was the staff, site development staff, who concurred, and Mr. Burns, who thought they were excellent consultants. And if that were true, I don't think you could approve any development on a landslide, because there's always the possibility that a qualified, even an excellent consultant was wrong once. So if that's the standard, I would just question, when could a landslide site ever be developed in the city of Portland?
Case-by-case determination.
But it would be based upon whether the consultant is right or wrong?
No, but I think in this case, we'd have to take into consideration a number of factors, including the environmental zoning designations. I mean, this is a heavily protected piece of dirt that also happens to have a landslide potential, and other factors adjacent to a sensitive natural area. There's a unique. I think we can all agree this is a unique piece of dirt. Whether it meets the test or not is a separate matter. But this is not a garden variety piece of dirt coming to council on a land use proceeding.
It's not a flat, unprotected site. I would agree with that. Yeah, there might be other sites similar to it somewhere in Portland because we have a lot of hills, but it's not a garden variety site.
Thank you, sir.
Could I just ask one more? And I'm sorry to sound like I'm nitpicking on this. I just want to make sure I understand it. So you said the traffic on Taylor's Ferry would be increased by 0.07%. Was that your testimony?
That was our consultant's report.
The consultant's report.
Yeah.
So
it was a traffic engineer.
I think we all agree it's a de minimis impact on a major thoroughfare. The question really for me I'm trying to get at is safety. So you have some number of houses. You have an outflow going on to Taylor's Ferry. The number of cars may be minimal, but you have more people using the bus stop, for example, and it might be a significant increase in the percentage of people using that bus stop. What can you tell me about the relative safety of Taylor's Ferry as it relates to the circumstances of the people who would be in this development?
Well, I know from TriMet's email that it has very, very limited ridership on those two stops. Our proposal has a pathway for people to go up to Ruby Terrace, a pedestrian pathway, to get to a safer route to the bus stops up by Taylor's Ferry, or to Terwilliger. So that was one way we identified a way to provide a safe means to get there. Now, the ultimate way to get people to the south side of Taylor's Ferry safely would be to put a stoplight on Taylor's Ferry. And PBOT would have to approve that, and they didn't recommend it even. Or to build an underground tunnel or a sky bridge, which we would get into the proportionality. How many people do we have that would possibly use that could justify that type of engineering and expense? And not to mention, we don't know if we could get the right-of-way on the other side necessary to build a tunnel. Now, I did hear a comment about a crosswalk. And there's conflicting views on this, and we've been through this during the hearing process. If you put a crosswalk on that street, are you inviting pedestrians into a dangerous situation? What we suggested is by putting improvements at our frontage, the new Hume Street, it is a little bit safer place to cross because the lines of sight are better. Our traffic consultant had to do site analysis. So by putting improvements on our side, we feel that it is safer to cross to the south side of Taylor's Ferry. Now, if the council imposed a condition that we stripe it with a crosswalk and PBOT supports that, I can speak for my client. They would not have a problem with that condition.
Very good. And could you tell me, again, I know you gave a number during your testimony, and I'm sorry I can't find it in the notes I took. You mentioned how many trees you were intending to cut. Could you give me that statistic again?
Well, I was reciting from the appellant's testimony that said 474. And I believe that's consistent. It sounds a little high, but I think Mr. Griffith has the exact number. It's in that area, though, and they're all in this disturbance area where we're concentrating the 21 lots.
Very good. Good. Great. Any further questions? Excellent. Thank you for your testimony.
Thank you.
And we, of course, reserve the right to ask you back up if we have further questions.
It'd be my pleasure.
Thank you very much for your testimony. Next up, we have the opponents of the appeal, 3 minutes each. How many people do we have testifying?
6 people signed up.
Very good.
Okay. The first 3, please come on up, are Steve Griffith, Barbara Griffith, and Jennifer Edeline.
Very good. And again, same deal. When the red light comes on, your 3 minutes is up. Please just state your name for the record. We don't need your address. Good afternoon, sir.
Good afternoon, Mayor Wheeler and Honorable Council. I'm Stephen Griffith. I am the applicant as well as a member of the South Burlingame Neighborhood Association. And my family has owned land in the Espionage area since 1932. We own and operate Riverview Abbey Mausoleum Company on Taylor's Ferry to this day. My grandfather built a home in South Burlingame in the late 1940s and in fact developed Ruby Terrace as a builder. My wife and my brother and myself are Espionage members. And the Espionage has really changed over the last couple of years. They went from a kind of a democratic organization where everyone could vote to a board-centered group where basically the board only gets to vote other than to elect board members. So it's really not representative democracy like it used to be. And currently the highest ranking board members live on Ruby Terrace, and there's really a situation where it's not in my backyard. It literally is in their backyard, and there's 4 board members that live on Ruby Terrace, some of whom testified today, including President Robert Lennox. I was actively involved in the hearings process and have heard the hearings officer's decision. Melvin Odin Orr is a distinguished member of the Oregon State Bar. He was recently appointed by Governor Brown to be on the Circuit Court of Multnomah County. He's a distinguished legal scholar, and I don't think he was given a lot of respect today for his opinion. He was put in that position for a reason, and I think his opinion was correct. Macadam Ridge is actually a showcase for environmentally sound development, despite all the critiques we heard today. 10 acres of the 14 acres we have offered to donate to the city as a permanent nature park or whatever kind of development you want to put on it, but it would be offered to you, the city. 1,400 trees are preserved. The tree cover along Ruby Creek and Stevens Creek is preserved, keeping the water temperatures cool. The sanitary sewer in Ruby Canyon will be replaced at no cost to the city. It's failing and needs to be replaced. A failed stormwater outfall in Ruby Canyon will be replaced at no expense to the city. Acres of invasive species will be removed. Thousands of native shrubs and trees will be planted, as well as extensive ground cover. Neighborhood connectivity will be improved. Emergency access will be improved for all existing residents as well as new residents. Access to TriMet buses will be improved as well. Macadam Ridge is good for the city of Portland and good for the people of Portland. Last fall, over 62% of the voters voted on a bond measure to increase housing for low-income people. Our housing development is for middle-income people, but we think a lot of people would benefit from it. And we ask you to affirm the hearings officer's decision.
Thank you. Good afternoon.
Hello. Good afternoon, Mayor Wheeler and the City Council members. My name is Barbara Griffith. Thank you for your time and consideration for our application and your patience today. We are not developers. We are a family. We are small business owners who have counted it a privilege and honor to serve the citizens of Portland. We offer employment, we pay taxes, and contribute to various charities. We are here today due to an appeal of our favorable land use decision. I have learned in life that there are two ways to make decisions. I call them the two Fs. Fear or factual. When we make decisions based on fear, our imagination begins to think of all kinds of scenarios to justify not doing something. It becomes an emotional decision. If you read what has been posted to livablepdx.com or what has been written from the Neighborhood Association, there is a lot of imagination going on right now. Yes, there will be land disturbance and trees cut to create our lots, just as there was to create their lots in the homes we're living in today. The SBNA has been, shall I say, unkind. Things have been said about my family that are not true, and things are being said about this development that are not true. They are playing a game with fear and emotion. We have gone from approximately 60-lot multifamily configuration, ending up with a 21-lot single-family configuration based on feedback from the neighbors and the city. We need to consider facts. My family has spent years and a lot of money to make sure that we have a safe building site that is environmentally sound. We have worked with the neighborhood association as well as the city, trying to accommodate both. It has been a long, hard road. However, with giving the extra time and money with experts, we have reports based on facts. When hearings officer Odom Orr looked at all the reports from 2 expert engineering companies, geotech experts, environmental experts, tree experts, and land use experts, he saw the facts and gave a favorable land use decision. In fact, Governor Kate Brown recently promoted Odom Orr to serve as a judge in the Multnomah County Circuit Court. Judge Odom Orr knows the facts as well as the law. I ask that you too would deny this appeal and affirm support for the hearings officer, favorable land use decision based on facts, not fear. Thank you.
Thank you. Good afternoon.
Good afternoon, Honorable Mayor and Commissioners. I'm Jennifer Edeline. Thank you for this opportunity to provide a statement in relation to the McAdam Ridge development. Today I'm here on behalf of my family, our business, as well as our community, in support of the affirmation of the McAdam Ridge development and in favor of denying the appeal. I also object to the manner in which the South Burlingame Neighborhood Association has handled this appeal. They have not accurately portrayed this development and driven out many of the people that are in favor of this development. As you know, Portland is now one of the top 25 largest cities in the country, as well as once again the #1 city to relocate to, and rightfully so. It's beautiful and it has a lot to offer. As a human resources professional, I hear on a regular basis the challenges individuals face with their families in mind in finding quality and affordable housing in or close to the city of Portland. This development is a low-hanging fruit for the city to increase availability of homes for our community. As the population continues to increase, this development will assist in increasing the supply of housing and reduce pressure on housing costs. Furthermore, benefits of this development, aside from the jobs it will create, are the opportunities to enable increased cultural and ethnic diversity amongst the neighboring community and the population as a whole, as well as the $1 million in tax revenues it will generate for the city to continue to fund many of the programs that positively impact the poor, vulnerable, and underrepresented men, women, and children of our community. I have no concerns about this development, as I know it was carefully designed to provide the least impact to the environment and the adjacent residents. In fact, this development was crafted to preserve over 70% of land, which is delivered in the form of a donation of 10 acres of untouched land to the city. This preservation plan includes 1,400 trees, as well as protecting Ruby and Stevens Creek. In addition, this development will not only preserve trees, it will also plant additional native trees while removing invasive plants. What I do have concerns about is if the decision of the hearings officer is not affirmed and the appeal is not denied, the impact and disappointment of the citizens directly and indirectly affected by the rejection of this housing solution. Today, I ask you to take this content of the statement in deep consideration as you look to move forward in affirming the McAdam Ridge development and denying the appeal. Thank you.
Thank you.
Mr. Griffith, I have 2 questions for you. One is, and maybe your attorney might want to answer the second question, but you mentioned that the houses would be priced in the middle income range. Did I?
Yes.
Is that the word you used? Okay. So yeah, what does the middle income range mean?
Well, the current houses on Ruby Terrace are in the 600 to 700,000 range, and I think it would be probably higher than that, probably 750 or thereabouts. We're not builders, but we've been told that.
So sort of 2, 3 bedroom, 4 bedroom type homes, or
they would be probably a 3-bedroom, I would think. I think we're talking in the neighborhood of 3,500 square feet.
Okay.
2-story.
And then the other thing, our attorney, I guess, it came up at the beginning of this hearing that we have to make a decision today in order to stay within our state mandated decision window. Is that what you want to see happen, a decision rendered today, or are you willing to give us more time to ponder a decision?
Well, I mean, Mr. Oden-Orr spent 2 months evaluating a plethora of evidence, and these documents that I brought in with me here represent just some of the submittals over 4 years. I mean, this site has been heavily scrutinized. We spend hundreds of thousands of dollars. We don't want a bad decision because you want it made in a few minutes, but I don't know what the laws are about what the rules are. We certainly want this thing to end. I mean, it's torturous, and it's not beneficial to anyone to have us keep spending money to develop property and then have people just throw every rock they can find at it. And we've tried to make the neighbors happy. We've tried to make the city happy. We've talked to BDS. We've talked to BES. We've talked to the PBOT. We've talked to everyone. And we've spent many, many hours. And to come down to making a decision in an hour or two, I mean, is pretty tough.
Yeah, I agree. It's tough. Thank you.
Thank you.
Next three, please.
Excuse me, Mayor.
Sorry?
Mr. Griffith, before you leave, you had been reading your testimony from a letter dated January 31st, and I think there are a few things in there that were not previously in the record, so I want to identify them as things that council is rejecting. So pretty clearly, none of us knew that Judge Oden-Orr was going to be appointed, so anything relating to his appointment was not in the record before, correct?
Okay.
Okay, and the other is, it's been brought to my attention by the appellant's attorney that information about the SBNA's, the language relating to exercising democracy to board vote-only body with extreme agenda, and the location of where SBNA board members live, that was also not in the record
I
before the hearing's office.
disagree. They submitted letters and they included their address, and those are in the record, and I've thoroughly examined the record.
Okay. In terms of the SBNA becoming a board vote-only body, was that in the record before the hearings officer?
Yes, it's in the record because the minutes are in the record, and the records record the number of votes.
Before the hearings officer?
I'm sorry?
The record before the hearings officer. That's what's relevant, is what evidence was placed before the hearings officer.
It was part of the appeal process. When they applied for their fee waiver, they included a vote.
So that would have come after the hearings officer's decision, therefore it would be evidence that's not in the appeal. I will just identify in the decision portions of this to strike that are information that came about after, but we don't need to wordsmith it line by line right now. So.
Without objection.
The last three are Anna Griffith, Robert Griffith, and Jacqueline Griffith.
Welcome. 3 minutes. Name for the record, please.
Hi, I'm Anna Griffith, and honorable council members and Mr. Mayor. The planning of this development had been going for over 4 years now. City rules indicate that maximum number of lots available for the site are 52 lots. In September of 2015, the applicant voluntarily reduced the proposed development from 46 to 23 lots in the hope of gaining approval of the neighbors and to reduce the environmental impacts. We listened to the neighbors and downsized the development in half. Later, neighbors wanted more space between the new development and their homes. We heard them, and we added the buffer green zone. The thing that we never heard from our neighbors was a thank you for your consideration. 12 different alternatives were explored for this development, and the best one was selected with the least environmental impact. Unfortunately, the neighbors opposed every one of the alternatives, including multifamily designs. The development footprint is in a flatter part on the side, away from the canyon, in a good distance from the Stevens Creek. In the final alternative, lots were reduced from 23 to 21 lots to be sensitive to the comments of the staff and to reduce environmental impact. We hire highly trained professionals to make sure the development is safe and environmentally friendly. Several geotech expert reports are in the record, and the city staff agree that these conclusions are the site for safe building. The neighbors are playing on people's feelings and fears, ignoring the fact that have been in the record, and the site is safe for building. Neighbors state in their own opinion, but do not have any expert reports or testimony in the record for geotech issues. The application met all the criteria in all areas, and that is why the hearing officer approved this application. In conclusion, I'd like to say that there is really nothing new was said today. It is more of the same thing. The neighbors have not made any arguments to overturn the decision of the hearing officer. He confirmed that we have met all the approval criteria based on evidence on the record. Honorable council members and Mr. Mayor, I respectfully request that you deny the appeal and uphold the decision of the approval of the hearing officer. Thank you for your time.
Thank you for your testimony. Good afternoon.
Good afternoon. My name is Robert Griffith, and honorable council members, thank you for taking your time. It's been a long day. I'm here to express my family's enthusiastic support of this decision, the approval by the hearings officer. This is an environmentally sensitive development by any objective standard. It marks an appropriate conclusion of a very lengthy process that's been very draining upon our family and our team. The design team has much expertise, environmental, geotech, trees, traffic, engineering, and they've met all the approval criteria. This comes as a great joy to us and our family, having held this property for 70 years because we want it done right. The hearing was fair, and everyone had the opportunity to be heard. The hearings officer was very attentive to everything that the neighbors said. He listened to them carefully, he was engaged, he asked follow-up questions. Their input was heard and considered. After 2.5 months' time to go through all this information, he was able to come to his decision, and it was based on substantial evidence in the record. On page 35, he indicated that significantly different alternatives were required, and that was based on information in the record, and that there likely could be no practicable alternatives that would be less detrimental to the identified resources and functional values than the preferred alternative. Also, he indicated that there's substantial evidence in the record that environmental review can be met with conditions. There are many merits to this plan. I'd like to highlight a couple. One, fundamentally, this plan honors the base zoning for the site, which is residential opportunity, but it does it in an environmentally sensitive manner. We're talking about developing just 4 lots, 29.5% of the site, and giving the rest of the site for permanent protection to the city of Portland. I don't think you see that very often, where 70% of the site is being given to the city of Portland. That includes many valuable assets, Stevens Creek, Ruby Creek, and the forest, 1,400 trees. Significant upland trees are being preserved on the north portion of the property. Many large and significant trees are there. Also, there's extensive mitigation that's been there in the conditions. It doesn't appear that the SB&A or their council saw them, because there's some 799 trees, 12,297 shrubs, Douglas fir, Oregon grape, and many things that will improve the forest understory. This is going to be a beautiful place when it's all done, a vibrant new neighborhood. We respectfully request that you deny the appeal and allow the hearings officer approval to stand. Thank you for your time.
Very good, thank you. Good afternoon.
Good afternoon, Mayor and Council. I'm here on behalf of my family, our business, and community in support of the Macadam Ridge development and denial of the appeal. I believe the development will have a positive impact in improving the housing shortage in Portland and has limited impact to the environment. As the fourth generation affiliated with ownership of the land and family operation of the Riverview Abbey, I'm here to defend my great-grandfather's dreams in building this development before he became ill. Please take this statement in consideration when making a decision and affirming the hearings officer's decision of approving this development and denying the appeal. Thank you so much.
Thank you, appreciate it. Was there 3 more? I'm sorry.
That's all who signed up.
That's all, very good. Okay, if they so choose, there's an opportunity for a rebuttal by the appellant. 5 minutes.
Thank you. For the record, again, my name is Carrie Richter, and I represent South Burlingame. The appellants. I just want to clear up a couple of facts. There's been some questions about the number of trees that are going to be removed. H100B is the November 3rd, 2017 shot study that the applicant prepared. It said there will be 505 trees removed. 478 of them are native. The applicant is proposed to plant 350 trees. There wasn't enough room on the site to plant enough trees to make the city's mitigation requirement work, so they've proposed to plant understory. I think that our position on all of that is, what does that do to the wildlife? What does that do to the corridor that exists in the West Hills here for the movement of animals? We don't know. And we've got this corridor. I think the evidence showed that we have this corridor, and the applicant, instead of pushing the development as far towards the existing development as possible, in other words, making these lots 3 through 8 as shallow as possible, pushing the lots back into the what we call the transition area, which is the area that's on the edge of a conservation zone. Moving those lots back could have made the actual open space remainder bigger. Instead, we've cut a hole sort of right through the middle of this corridor. And this is the kind of clustering, this is the kind of alternative that we're talking about here. We're talking about moving roads, reducing the width of Front Street, or otherwise changing. Front Street is the street where the 54-inch tree is. We're talking about reducing the width of that road, figuring out a way to relocate some of these houses to allow the environmental resources to remain. And those are the kinds of things that alternatives that were not considered. The applicant talks about the 11 alternatives, and that there was a multifamily proposal included. That multifamily proposal was for 42 lots, 2,500 square feet a lot, with 8 single-family lots and a bigger disturbance area. So, of course, that multifamily alternative is going to have greater impact on the natural resources than the 21 lots that are now proposed. I want to talk a little bit about whether or not there's anything that the neighbors would be satisfied with. I think that you've heard a testimony after testimony today from members of the neighborhood association that they understand that this land will be developed and that there is a development that is appropriate. Is it a development that is compatible with and fits within, is visually subordinate, and allows the wildlife corridor to continue to remain? And that is what the finding that the hearings officer didn't make. The applicant talked about how they were able to produce expert testimony, and that the expert testimony was what was relied on by the hearings officer making the decision. I would be remiss if I didn't point out that the neighborhood association tried to get expert testimony to counter that testimony and was intimidated out of producing it. So it's not as though the hearings officer was able to weigh expert testimony on both sides because the neighborhood's testimony was silenced. I've talked a little bit about the ability to reconfigure this neighborhood, to reconfigure this slightly, and I think that that's the point that staff was making, and I think it's the point that a lot of people have made, is that this development just isn't fully baked yet. We haven't evaluated the disturbance area. The hearings officer couldn't find that the disturbance area was certain at this point, so he had to impose conditions. And our concern is that the imposition of conditions could alter the disturbance area and impact the mitigation. And there are a number of LUBA cases that say you cannot defer a discretionary determination to a further hearing without providing notice and opportunity to participate. So if these decisions are going to be made in the future, the public should have an opportunity to participate.
Thank you.
I'd be happy to answer any questions, and I appreciate your time.
Commissioner Saltzman.
So your clients would support the clustered proposal that you just articulated a few seconds ago?
No, because the disturbance area was bigger. I think we would support a cluster development that had a similar disturbance area. Again, that is that complements.
The option you just described of narrowing lots 3 through 8, clustering the development, is not an option that your clients support.
They would support it, I believe.
Oh, they would support that.
Because I think that would allow for a greater protection of the resource. I mean, again, that wasn't one of the alternatives that was proposed.
That was not one of the 10 or 11 that was proposed? Okay.
Commissioner Fritz, did you have a question?
No, thanks.
Very good. Thank you.
Thank you.
Did you have a question? Okay, good. So, colleagues, we are at the end of what I would describe as the public participation part. The conversation can go in any number of directions. We know what the various alternatives are. We can close the record if that is our thinking. What I'd recommend is maybe to help focus the conversation or shape the conversation, if I could get a sense of what people are thinking at this particular stage, having heard all of the testimony and the evidence both sides.
It is extremely unusual for us to get a case like this where 5 city bureaus are saying no, recommending that they don't have the information that they need to support the application. And can't remember seeing, it's not in the record, but the current hearings officer decision copies and pastes from the application or from the applicant's assertions to a remarkable degree. I can't find where the hearings officer says that this can be addressed with a condition of approval. There are places where I can't find that condition of approval, in particular with the landslide hazards and the grading that would be necessary for that. I'm also very concerned about the trees, both the street trees that are not present. Thank you, Ms. Andrews. But particularly the biggest tree on the lot, which was pointed out is under the Southwest Hills Protection Plan and the environmental review criteria, we're supposed to consider which, the subdivision, the whole plat is supposed to look at preserving the most significant resources, and it seems that that has not happened. Instead, this hearings officer has given a condition of approval that the city forester has to approve tree removal. Well, the city forester has said, no, we shouldn't be removing that tree. So I recognize that it has been a long process for everyone. I'm not convinced that the alternatives analysis has been fully vetted. I would be willing to approve the environmental violation review, which would mean that the restoration could start taking place. And then I believe that the applicant and the neighborhood should maybe go to a mediation and for a new application that fully involves the staff right from the beginning, rather than the hearings officer having to make multiple determinations based on evidence that's submitted very, very late in the process.
Thank you, Commissioner. Anybody else?
Well, I guess
Commissioner Saltzman.
I guess if I'm forced to make a decision today, I would try to get to a win-win decision. I think there was a lot of merit, obviously, in what the neighbors had to say about their concerns, but I also found a lot of merit in what the Griffith family had to say about how their efforts to make something work here. And I think that if the other members of the council were supportive and it's legal for us to do that, I would specify that we save the 54-inch tree as a condition of approval, that we require the clustered development that narrows lots 3 through 8 as being the chosen option. And I would support that. I think there is a need for housing in the city, and I'm, you know, I do agree with that. We want people to be able to live and work in the city. And I think there's a lot of merit in the proposal in terms of replacing sanitary sewers in Ruby Creek and protecting Stevens Creek further. So yeah, I think there's merits to both sides, and if that's what I would propose as conditions of approval.
Commissioner Fish.
So Mayor, someone mentioned this has been a long day. Council started at 9:30, but I don't remember a more thoughtful set of presentations, and I also appreciated all the testimony. And even when we have a long day like this, I find these land use proceedings fascinating because we're getting at fundamental questions about the kind of city we want to live in and the future of our city. When we are called upon to make a decision because we're up against the clock or because we have to, this body has demonstrated time and time again they're willing to make a decision. I am frequently surprised by where we end up, which is another way of saying it's an honest process where everyone comes, listens to the testimony, and gives their best judgment. So I defy anyone to handicap the outcome of these kinds of things because we come with an open mind, and often the discussion that we have as colleagues shapes the final outcome. If I am required today to vote on this, I will vote to uphold the appeal. And I will do so largely on the basis of what Commissioner Fritz just identified, and I thought it was the most compelling part of Ms. Richter's closing. It was the last thing she said. There are simply too many Bureau conditions that have been deferred that require discretionary actions which will have to be decided, perhaps or not decided, because the bureaus may not, under a feasibility analysis, reach any kind of agreement. And those decisions will not be subject to any further hearing and public testimony. And Commissioner Fritz is absolutely right. There's a difference between putting conditions of approval that are sort of plain vanilla and simply punting on a whole host of things where the bureaus have significant disagreements about the project and expecting at some point it will be deferred, like, for example, BES on the stormwater, the feasibility of a stormwater facility in the disturbance area. It's a very big deal, and if I learned anything, that has potentially significant impact on the stability of the site and some of the consequences to neighbors. So if I have to vote today, Mayor, I would vote to uphold the appeal. I may do it on a narrower basis that Commissioner Fritz has proposed, and she's historically been the expert on this panel on these matters, so I would follow her lead on what we would be upholding. I think what Commissioner Saltzman has proposed as potentially a win-win always has merit. I am reluctant to decide here in my seat what should be the elements of a deal acceptable to the neighborhood and the developer. While I respect Dan has listened carefully and is in good faith offering a path forward, I think we've had more success getting in those situations where there is a genuine willingness to reach an agreement. We've had more success in the past simply calling a timeout, getting an agreement to stop the clock, which is at the applicant's discretion, and then either setting up a mediation or a process where it comes back to us knowing we are going to decide the case. So the incentive is either you work it out or there's going to be a binary choice, and you may or may not like it. And so we've done that. So Mayor, if I am required to vote, I will vote to uphold the appeal largely on the grounds that Commissioner Fritz has articulated, and I think Ms. Richter made very clear in her closing statement. My preference always is to have the parties reach their own mediated agreement because it's more sustainable, and I think there was a lot of nodding in this room when someone said that if not this development, there'll be some future development, that we're not going to stop. One one cannot stop development on this property. The question is, what's the character of the development and how is it done? So I would welcome an opportunity to have the parties have some further dialogue, but that solely rests with the appellant, excuse me, is that right? The applicant, because only the applicant can waive the clock that we're under. And if we don't have additional time, then the council will, as we do in any case where we're required to, will render a decision.
Commissioner Daly?
I'm agreeing with Commissioner Fritz and Fish. I have significant concerns about the wildlife corridor, about the landslide issues, the trees, and it seems like almost everyone today has been saying things that were not previously in the records. I'm hesitant to say this, but if I do want to say I'm disappointed to hear that multifamily was rejected. If we are going to have a sincere conversation about affordable housing and increasing our housing stock and density, then multifamily shouldn't be off the table, but frankly, $750,000, 3,500 square foot homes are not going to help either. So, yeah, that's where I'm at.
Thank you. Commissioner Fritz, you wanted to speak?
I appreciate all the comments of my colleagues, and I know the mayor hasn't had a turn yet. I just wanted to weigh in again and say that we get one application fee, and the staff has put an enormous amount of work into this, basically pro bono at this point, that the taxpayers have been funding all of our staff's work. It's not possible to condition an approval based on saving that tree because the entire subdivision is based on having the street in that location. I would also concur with Commissioner Daly, and in fact, I'd go further. And I asked the question at the beginning about the definition of the site, and my trusty staff gave me the information from the zoning code saying that the applicant can choose to define the site as the portion of ownership that is proposed for development. There is actually more property that's in the same ownership that is further towards the northeast that might be appropriate for some multifamily units that be much closer to Macadam that would have better sight lines on Taylor's Ferry. And so I believe that the best option is to start over with the understanding that I'm hearing from everybody that something should go on this property and that there needs to be a very good faith working together, recognizing that we certainly, I don't think anybody wants to get to this point again, whether it's quickly or slowly. We want to get to a better design that has full engagement by everybody from the beginning.
I agree with the thrust of my colleagues. And so as the applicant, you can count the votes. And my suspicion is you don't want us to take the vote today. But it's your call. And so if you're willing to take another swing at this, this is your call. I happen to agree with a lot of the public value that you've put on the table. There is a significant amount of public value being put on the table. I am very concerned about the city's own process, and I'll have a different conversation with different people about that at a different time. But it is very notable that we had a hearings officer come to a conclusion with so many critical city bureaus still not confident in the answers that had been provided. And in my opinion, that is an unacceptable place to land. And I'm not willing to leave the unanswered or the open or the ambiguous questions to chance. They're too significant in my mind. So we can take the vote and we can go home, or if you'd like, Commissioner Fritz.
I just would like to get staff's assessment on the feasibility of just continuing this process versus starting over. Because I'm very concerned about the precedent we set.
Yeah, I don't think it needs to start over. I think
looks like
Dan, after
if we vote to uphold the appeal, then it either starts over or gets appealed.
Yeah, that's correct. Dan, just listening to and weighing the evidence, came up with one possible reasonable solution. I'm not saying that is the solution, but I don't think you have to start from ground zero. I think there's an opportunity here, as Dan said, for a win-win, but again, it's not our call, that's the applicant's call.
City Attorney wanted to say something.
Generally speaking, we don't really like to give you legal advice that boxes you. I want to make sure you have reasonable options. I'm a little concerned on this particular case. We often, as you mentioned, we often give the parties the opportunity to go back, talk, figure out another option. In this particular case, state law has some limitations on how many extensions we may grant, and we're there. And if the applicant wishes to talk about that, that's fine, but I want to make sure that's on the record.
Fair enough. We had a request for staff, city staff, to come back, please. Commissioner Fritz.
I just would like your experienced assessment of the question of staff time and whether it would be better to start over or to try to amend this proposal.
I can try to speak to that again. Kate Green.
Is your microphone on, Kate?
Yeah, it is.
On.
Oh, there you go.
There we go. As a reminder, this is an on-the-record hearing, so there really isn't the opportunity to accept new evidence, such as an alternative new plan that hasn't been presented or discussed or evaluated. And the plan that was mentioned as far as clustering and modifying to preserve a tree or other trees, that plan isn't in the record, and there's been no evaluation of such a plan. And I believe that a new application would be necessary to undertake that evaluation.
I think that's right.
Yeah.
I think it's cleaner, too. I mean, it says, I think, Mayor, it was useful to hear from a number of people that development is inevitable, so this is not a question of holding back progress forever. But if given the state of the record and the fact that so many bureaus have hedged their bet and deferred doing analysis, landing on some of the questions that they were asked, I think in some ways it's more productive to go back to square one. Have a different set of alternatives presented with a friendly admonition that should it ever come back to us, it is not helpful to our determination to have both sides say disparaging things about each other. And I would say to those who are opponents of whatever is being proposed, I think we all ought to adhere to high standards of how we engage in these processes. And likewise, when we have the other side commenting on a hearing officer or the level of behavior, that doesn't help us make a decision. When we have records in the evidence about emails that are open to interpretation, that does not help us reach a decision. What helps us reach a decision is have the parties, has the applicant put a reasonable proposal on the table? Does it in conformity with state law? Has there been an honest engagement of the neighborhood? And then, and only then, does it come to us if there's something to be resolved? But this body would much prefer to have those decisions decided by the applicant and the community that's impacted. And usually we get better outcomes when that happens. My 2 cents.
So I move that we approve the appeal of the South Burlingame Neighbourhood Association against the hearings officer's decision to approve with conditions Macadam Ridge, a 21-lot subdivision, environmental review with modifications, but approve the environmental review section of this application.
Second.
We have a motion from Commissioner Fritz. We have a second from Commissioner Fish.
Mayor, this is
Did I state it correctly, City Attorney?
Yes?
I think you said you want to approve the environmental violation review. I think you said.
That correct?
Yeah.
Did I not say that?
No, I think you said the environmental review.
Oh, sorry. Thank you. So.
So is this a tentative?
So let me try again. It's very late. I'm reading from a paper and I literally did not do it correctly. Appeal from the uphold the appeal of the South Burlingame Neighbourhood Association against the hearings officer's decision to approve with conditions Macadam Ridge, a 21-lot subdivision, environmental withdrew with modifications. Period.
Second.
We have a motion from Commissioner Fritz. We have
And
a second.
and then approve the environmental review.
Violation review.
Violation.
So council, what do you want us to do
Oh, dang it,
now?
I did it again.
So I'm
The
wondering,
environmental violation review, thank you. Got there.
so Sean, would it be possible to put that language up on the screen from your staff report? Or is that too challenging?
Oh, that would be very, very helpful. I was trying to find that and I couldn't at this hour dig that out. Was there a second to mine? Usually
Commissioner
second.
Fish.
Yeah. And while you're finding that, I would just note that the applicant gets to choose at the very beginning of the process whether this appeal was on the record or not, and that's why we're in this situation.
And to be clear, it's a tentative vote, and we'll be coming back with findings next Wednesday morning.
Thank you.
It's the 14th, right?
Yeah.
So Commissioner Fritz, are you identifying the fourth?
Yes.
Motion as your motion?
The one that's currently
With the
highlighted.
exception of approval, yes, that's the one.
So perhaps we could get a new second, because the language has changed a bit.
Second.
We needed to update the second. It's getting a little tiresome.
So we have a motion from Commissioner Fritz. We have a second from Commissioner Udaly.
We'll take a tentative vote.
This is a tentative vote. The final vote would be next Wednesday, February 14th, during the council's AM session. Call the roll.
We need to state the time. Yes.
Yes, we need a time certain, please.
It'll be 11:30.
11:30, February 14th will be the final vote.
I'm sorry. 11. I've got a couple other items here.
And by the way, given our
11
recent,
a.m. Okay,
given
so-
our recent history, Mayor, I think we should let people know that's probably closer to 12.
Yeah, no
Or
kidding.
three.
So
Or three.
this is a tentative vote. The final vote will be on February 14th, Wednesday, 11 a.m., Portland City Hall. Be there. On the tentative vote, call the roll.
Fritz.
This has been a really great hearing, lots of really good testimony, very well organized. I'm very, very impressed with everybody who spoke. Thank you to the staff. I know that you have worked really hard to try to get to. Yes, I do believe that this property will be developed, and I think everybody's aware of that. So I think there's a lot of scope. It's a big property. There's lots of different parts of it. I hope that I hope it doesn't come back on appeal, because I hope you can get to something that can be approved by the hearings officer. If it does, then I will be looking for significantly different alternatives that greatly reduce the disturbance area, do look after the values of the upland forest. I think that was part of the testimony that was very compelling to me, is that the resource values identified in the Southwest Hills Protection Plan include values of the upland forest by itself rather than just as protectors of the creeks. And I also am very concerned about the landslide hazards. Usually, given that the whole of West Portland is in a landslide hazard area, I don't give much credence to that. I think the testimony that was presented today and that's in the record is compelling, that this site needs particularly careful evaluation for both the streets and the lots to see, to make sure that that landslide hazards is diminished both during construction and afterwards, and to me that would entail retaining some of the trees both during and after construction. Aye.
Fish.
I want to echo what my colleague just said. I think this has been an exemplary hearing. I think it's important that we acknowledge the Griffith family legacy of how they have managed this property and the business. It is my hope that as a result of our action that there can be some resolution of the differences and a proposal that gets approval. I would hope this does not come back to us, assuming this is not appealed. If it does, I too will be looking closely at impact on trees, impact on the wildlife corridor that the Olmsted brothers over 100 years ago identified as one of the most significant natural features of the West Side, erosion control and impact and mitigation measures, and how the stormwater is managed on site. Aye.
Saltzman.
Well, excuse me. Well, I see heads nodding about this property will ultimately be developed. I'm not sure I'm totally convinced that's the sentiment of everybody who may be most affected by development of this tract of property. And that's just kind of the way we are in Portland. You know, intellectually, we all accept growth and density and all that, but when it comes right down to something in our backyard, it's an entirely different issue. So I'm not going to impugn anybody's motives here, but I will say this, that I think we're better off having this property developed by the Griffith family than some out-of-town developer from California that's going to swoop this up if the Griffith family tosses their hands up and says, we can't do anything with it, you try. And they're going to have a lot more resources to bear, and I think this council has spoken, just about everybody here, saying we see this being developed too. So I think it's just a question, it's, you know, my admonition to everybody here is you should come up with a solution that works with the Griffith family. I think that's the best bet to environmentally sensitive development that will provide home ownership opportunities. Now, I would like to see a multifamily option considered as much as anybody else because it does speak more to the affordable housing crisis. But as I said earlier, you know, home ownership is a good thing, period, for people to be able to live near where they work. So that's where I'm coming down. I'm going to support the appeal at this point, but this isn't going to go away, and I think the neighbors are best dealing with the current owners of the property to come up with something, and I think the current owners of the property have gone a long ways, I think, towards offering some options here that do provide public owners or public open space as well as environmentally sensitive development. It's not totally there, you know, like save that tree, but it's probably closer than we're going to get with some out-of-town ownership coming in to develop this piece of property. Aye.
Daly?
As is often the case with these land use hearings, it's really preferable if opposing sides can come to an amenable agreement, because as Commissioner Saltzman mentioned, sometimes there's a much less desirable alternative than what either side is hoping for. So I vote aye, and I hope this can move forward.
Wheeler.
I want to thank Dan for setting the right tone, which is we want to get to a yes win-win on this. And I want to acknowledge the Griffin family. You are an old Portland family. You have contributed mightily and positively to this community, and you've put some wonderful ideas on the table. And to the community, I would say this: you've raised very reasonable objections today, compelling objections in terms of where we are today. It is my view that this is a complex site for obvious reasons. It has all the overlay issues, but ultimately it is a developable site, and it is my belief that it will be developed. And so now the question is simply, how do we shape that development and where do we take it from here? So I hope all of us can take this as a serious challenge, rise to the occasion, and get to the point where we are saying yes. So I concur with my colleagues on this. Thank you for everybody who is here today. I know that ultimately there are many people disappointed by this decision today, but I think it is the right decision for today. I vote aye. The motion is approved, 5-0. We are adjourned.